Good morning and welcome to the District of Columbia Court of Appeals. Apologies that we're taking the bench late this morning. Didn't mean to keep you waiting. Our first case on the calendar this morning is 23 CV 150 and 151. CHASTLETON Cooperative Association Incorporated versus KAWAMOTO Notes LLC and CHASTLETON Cooperative Association Incorporated versus Federal Home Loan Mortgage Corporation et al. Counsel, if you could introduce yourself.
Good morning, Your Honor. Michael Goki on behalf of the appellant, CHASTLETON Cooperative Association, Inc.
Thank you, Mr. Goki. And if you could let us know how much time you'd like for rebuttal.
2 minutes for rebuttal, please.
Thank you, sir. Whenever you're ready.
Thank you. Your Honors, may I please the court? We're here today for two cases that are related but have different, slightly factual issues. But the overriding issue in both cases is the same, that neither appellee has any right to enforce the recognition agreement. I'd like to start with RFB. RFB Properties purportedly purchased the stock and the lease agreement of a Stephanie Sipek after she had defaulted under her lease and under her obligations to Bank of America. Now, this case originated because CHASTLETON sued RFB because the foreclosure was improper, because CHASTLETON never received notice about the foreclosure sale in the first place. And under the bylaws, under the occupancy agreement, and even under the recognition agreement, CHASTLETON was supposed to receive notice of any foreclosure sale before it happened. Now, the parties tried to go to settlement and CHASTLETON was okay allowing the sale to proceed, provided that it was paid as it was entitled to be paid under its governing documents and under the applicable contracts. And so when RFB objected to that, CHASTLETON filed the suit to determine the parties' rights. Now,
well, not as it was entitled to be paid under the recognition agreement. You agreed to be paid if you were paid in full, whereas the recognition agreement would have allowed you 3 months.
well, even under the recognition agreement, fair point, Your Honor. My point was that even under the recognition agreement, there was supposed to be notice to the CHASTLETON if there were to be a foreclosure agreement. So, but Your Honor is correct that
Could you just walk me through why you think that's true? You know, they say that's not what the recognition agreement says. I've read that paragraph of the recognition agreement 100 times, and I cannot make heads or tails of it. So what is the line that says the CHASTLETON gets pre-sale notice?
it says that, excuse me, Your Honor, that no foreclosure may happen unless the CHASTLETON gives its written approval.
I mean, I take it you're looking somewhere at A174, paragraph C, 1, A through C. Where is the prior written approval? I don't think that exists. There is something about 30 days after receipt of written notice. It doesn't say that's pre-sale notice. In the event,
I agree, Your Honor. It's not clear. It's not clear about whether it's pre-sale or post-sale, but it has to be with their written approval. And they never had they never provided any approval for the foreclosure sale.
where's the written approval part? But we don't, who cares about written approval? You definitely didn't approve.
That's right, Your Honor.
And you say it requires approval. But the recognition agreement also restricts your rights to withhold approval to, you know, lack of creditworthiness of the buyer. None of that's been alleged here. So
Right.
I think part of their argument, or at least an implicit part of it, is to the extent that CHASTLETON, it's kind of the whole case, has withheld its approval of the sale, it has been only for obstructionist purposes to try to recover more than what is due to them under the recognition agreement, and not for any valid reason that's permitted under the recognition agreement.
But our position, Your Honor, is that the recognition agreement can't even be enforced by either of these parties, because that was a contract with Bank of America, not with KAWAMOTO Notes and not with RFB Properties. And so when KAWAMOTO Notes obtained its interest in the note, and it did that, it claims, because it was endorsed in blank. It says this note was endorsed in blank. We're the holder of that note.
Can I just ask that? This is a very basic question, but what was the recognition agreement for? What's the purpose of it?
The purpose of it, Your Honor, is related to the security and to the transaction. It's related to Ms. Sipek's loan in order to purchase the cooperative shares in the CHASTLETON.
Right. And but it has 3 signers on it. right?
Correct.
It's not just Ms. Sypek and it's not just the lender. It's also it's also your client.
It's also with the CHASTLETON. And if Bank of America were enforcing this recognition agreement, then they would have that right because they're a signatory to that contract.
But you're saying no successor, it creates security, but it makes it pretty much inalienable. Because if Bank of America alienates it to anybody else, whoever is, purchases the interest has no enforceable rights under the agreement. That's your view. It's like a BOA specific security that you think was created by this document.
Not necessarily, Your Honor. They might have had the opportunity to assign it, but there's no evidence in the record that they did that. The contract, the recognition agreement cannot be modified or amended except in writing by the parties. And there was no
So that's where I
modification.
get confused. So it's not that the agreement is unassignable on its face. It's an evidentiary issue that there's no evidence of assignment.
That's correct, Your Honor. That's correct.
Okay.
And when we look at the record, when we look at the documents that Kawamoto cites as saying it has received Bank of America's rights, Kawamoto is not even identified on those documents. Those documents are between Freddie Mac and RFB Properties.
I thought Kawamoto's argument, I think, is something like they're holding the note endorsed in blank, and they the rights that were created by the recognition agreement travel with the note without a requirement of any specific separate assignment of interests. I understand that to be their argument. Do you understand that also to be their argument?
I think that's where they end up, Your Honor. But I think before they get there, there's a few different arguments they make. And one of the arguments they make is that BOA or their successors assigned the recognition agreement to Kawamoto.
I take your point that at least as far as I recall, we hear from the other side something different. I take your point that I don't recall there being anything in the record of a specific assignment of the interest in the recognition agreement. So that's consistent with my impression of the record. But what's your response to their somewhat more abstract argument, which is, we're the holder of a note endorsed in blank. That's like a $20 bill. I have it. As long as I have it, I can negotiate it and assert rights under it. As a matter of kind of related law, a holder of a note like that succeeds, also has the power to enforce the interests of the original parties to the note.
They absolutely have the rights and the power to enforce the collateral on the note. And the collateral on the note was the stock certificate and the occupancy agreement, not the recognition agreement. And even in the memorandum of sale.
But that kind of gets me back to my question about what the recognition agreement says. I mean, that seems to be saying that it's not assignable, right, on its face, right? Like, because otherwise, what is the point of having three people sign this agreement, right? Like, it seems like inherently it has to be assignable. Am I missing something?
No, you're right. And again, to be clear, it could be assignable, but there was no assignment here. Merely because there was a foreclosure did not assign the recognition agreement. Because what happened at the foreclosure sale? Two things were sold, or there was the collateral. It was the collateral for the loan security agreement. And the collateral was the lease, the occupancy agreement, and the stock certificate. Those two things, those are the two things that secured the note. Your Honor is correct that this is an additional agreement that provided Bank of America with additional rights and additional support. But the collateral,
to be clear, that right, those rights were rights of recourse and legal duties that your client took on relative to Bank of America.
correct.
Because it's a more complex than a typical mortgage. There's three entities involved, and if there's a default, it could be a default against two entities, and there are people standing in line, and so you need to have an arrangement, a structure for how those rights are going to be resolved among the three entities. And you're saying that whatever rights are conferred upon the lender by the recognition agreement are limited only to Bank of America unless there's a formal assignment.
Correct.
And none of them kind of travel by way of third-party, intended third-party beneficiary doctrines or other doctrines. None of them travel with the holder of the note. There has to be a specific assignment.
That's correct, Your Honor.
I understand that to be your argument. Why? Do you have legal support or case law that suggests that that's the right answer, or do you have a reason why you think that's how the law should be?
Yeah, I don't think there's a single case that's on point. I think both sides have sort of taken portions of different cases to try to make their argument. I think where we begin is contract interpretation. And when we looked at the recognition agreement, it says this agreement may be modified or amended only in writing executed by both parties hereto. So it was never modified, it was never amended, it was never signed.
Is as a matter of general contract law, is enforcement of a contract by an unspecified but recognized as a matter of law, third-party beneficiary treated as a modification of the contract, or is that treated as interpretation and enforcement of the contract under the structure of law about when you have a third-party beneficiary who can assert rights under a contract that didn't name them?
I think then it would depend about whether or not there's a third-party beneficiary that could enforce the contract. And the Superior Court, that was not the basis for the ruling. They ruled that no, when the foreclosure happened, the rights to the recognition agreement traveled along with the collateral for the note. And
can I ask you with this idea, I think you agree that our prior cases suggest that certain rights travel with a note. If you're the holder of a note, there's certain rights that travel even if there's no formal assignment. Do you agree with that proposition, stated that broadly, or do you?
Yes, yeah. Again, the notes, the right to enforce on the collateral of the note travels without any assignment.
Even though as a matter of contract, the contract might not say that, and there may not have been a formal assignment of that authority.
Correct.
And the reason for that, I infer, but see if you agree, is because that's a sensible way of interpreting the intended structure of the transaction and the remedies that you would expect people would be understood to have.
I think the cases are consistent that when even with a holder in blank of a note, they have the right to enforce the note. They have the right to enforce the collateral.
My question for you, I guess, is why do you think that if law recognizes the ability of a holder of a note in blank to enforce rights under a contract to which they were not signatory and that was not formally assigned to them because it makes sense, why do you think that where it has so far been recognized as making sense is different from here? Why would it not make sense to reach the same conclusion here?
Well, for one, the courts have never reached that conclusion before, as far as
or contrary in your view. So
or contrary, that fair enough. But the concept that the rights would also pass on to the recognition agreement are contradicted, if I can step away from a policy perspective, by the facts of this case, because in the memorandum of sale, it made clear that the purchaser was taking the collateral subject to any liens, the corporation bylaws, and the other documents. Nowhere in the memorandum of sale does it make any reference to the recognition agreement. In fact, the opposite. It sort of is a warning to the purchaser that they're on notice that they're purchasing this collateral subject to those liens. So why does it not make sense? Because here, Bank of America and the appellees have made this position that it's an incentive for banks to loan to people purchasing shares in a cooperative in situations like this. But again, what Bank of America does with that is a contract after that point with a recognition agreement becomes contractual in nature. There's just no authority that, and it wasn't the intent of our clients to give Bank of America that authority to pass along these rights under the recognition agreement without any notice to the CHASTLETON. That just was not the situation. They never received any notice that Bank of America was intending to do this. And even when you look at—
And to be clear, is it also your view then that the successors of bank, barring an assignment, the successors of the Bank of America had no legal obligations to your client under the recognition agreement, so that they, if Bank of America sold it to someone and then that person had a foreclosure sale, they would have no obligation to provide notice to your client and a right of first refusal?
So there, Your Honor, under the bylaws of the corporation, no member's interest can be transferred without the approval of.
There may be other impediments that you could rely on. I'm just wondering conceptually if the logic of your argument is that non-formal assignee successors of the bank that was a party to this contract would, in your view, have no legal duties under the contract because there was no assignment. They're not a signatory. And so they, the duties don't travel with the note either.
I think
asking about your theory.
Yeah, I mean, I think either it applies or it doesn't. And if the contract applies, then they would have that obligation to provide notice. And if it doesn't apply, then they would have no obligation. But so I think that could be fair.
Can I ask you, just as antecedent questions too, you had, I thought, a separate argument about why you thought RFB Properties might no longer be an appropriate entity to be involved in this case, at least in certain respects, because of the statement in their, I think their answer or somewhere, that they had assigned, that RFB Properties, the entity, had assigned its interest to RFB, the individual.
Thank you, Your Honor. Yeah, they make that in a few places, beginning with their cross claim and their counterclaim. It's right from the get-go. They take the position that, you know, we were the winning bidder at the foreclosure sale, and then subsequent to that event, but before we went to settlement, we transferred our interest to Mr. Brown. So if RFB transferred its interest, then they no longer have equitable title. They've transferred those rights away. If they think they're a third-party beneficiary, they've transferred those rights away. They're not the proper party in interest in this case. And
Well, to be clear, you think they're not a proper party in interest as a cross claimant? I mean, you sued them. Are you saying you think we should dismiss them from this action as a defendant?
No, I'm saying that it was error for the court in terms of the cross claim. That's correct, Your Honor, because they had no rights under the recognition agreement, and they are in their counterclaim, as I recall, they were asking the court to declare two things really. One is to order CHASTLETON to go forward to settlement, and two, to acknowledge the hierarchy of how the distributions would take place with the sales.
Did you make that argument in the trial court?
I was not at the trial court, Your Honor, but
Was the argument made by your client or their counsel at the trial court?
I'm sorry, which specific one?
Whether that RFB is not the proper party to be bringing those claims?
Yeah,
it's
we
a
have
real party and interest argument, right?
We have made that argument in the record, Your Honor. It's at A174 in the, no, that's not correct. It's an bear with me. We certainly made it in the motion for reconsideration, and I believe they also made it in response to one of the motions. I could, on my break around, I'll try to track down the specific site. I see that I'm out of time. If the court has any more questions, I'll see the rest during rebuttal.
Just one thing. So when you say we lack notice of the sale, one response that opposing counsel gives is, well, they filed a cross claim saying they did provide proper notice of the sale. You never answered it. So it should be deemed admitted under Rule 8. What's your response to that? I don't know if I saw it. I don't recall it in your reply.
Yeah, I think the court can rely on the record. It can rely, the court has discretion to rely on what it wants to rely on. And here there's no evidence there is that bald face allegation, but there's no other evidence aside from that allegation as our response.
Yeah, forget about evidence though. They're making a legal argument that under Rule 8, Superior Court Rule 8 says that somebody files a complaint that requires an answer, question whether or not an answer was required here. But if it requires an answer, and an answer is not filed, the facts in the complaint are deemed to be admitted. So I'm not talking about what evidence in the record is. I'm talking about why isn't this deemed admitted under the Superior Court rules?
I can't speak as to why that pleading wasn't filed, Your Honor, whether it was because the motions were pending and whether.
I'm not asking about why the pleading wasn't filed. I'm asking why it shouldn't be deemed as an admitted fact that your client was properly notified.
I guess I don't have an answer for that, Your Honor. I would say that, you know, it would obviously lead to a harsh result, and there might have been there may have been reasons why the answer was not filed, but I'm just not privy to them.
Can you, I mean, if I'm a little puzzled, I guess, about what should be done if you took their affirmative statements of assignment as oh, I'm back on notice. Sorry. Yeah. Sorry, I was conflating assignment and notice. And did you know if in their answer as well, they contested and asserted that they gave proper notice? Or is it in their case, it was in their counterclaim, or where was it that was done, or you're not sure?
In our complaint, we said there was.
Well, I know you alleged lack of notice, and
Yeah.
I think you pointed to some materials where there were statements where there was a statement by RFB that there had not been notice, an acknowledgement of RFB that there had not been notice.
Right, Your Honor. Well, in the documents that Kawamoto relies on to say that Bank of America assigned rights to it, that those transactions between Freddie, their statements between Freddie Mac and RFB, and in those, Freddie Mac says that it never obtained permission or provided notice to Chastleton ahead of time.
So those are statements by Freddie Mac, not RFB.
RFB signed the agreement as well. So this is an acknowledgement of the transfer of rights from RFB of the stock and of the occupancy agreement from Freddie Mac to RFB.
So do you think that's an admission? You would think, do you think of that as an admission by RFB? And it's just a little puzzling what we would do if we have an admission by one party and an admission by failure to contest by another party and they're opposite. It's like, what are we supposed to do?
I agree. I agree. I think it's muddled, Your Honor. I think there's facts and evidence, and the court could make findings that go both ways, but there's a dispute of facts there. And this is a summary judgment order. And where there's a dispute of
Did
facts
the court say anything about this in its partial summary judgment order
about the
lack of notice?
I think the court concluded that it found there was proper notice. So my recollection is that the court didn't analyze that in depth.
Well, for the benefit of opposing counsel, I'll say I think your recollection is incorrect and that the court did not say anything about there being proper notice. In fact, suggested that there were disputes of material fact as to whether or not the sale was proper, and then said nothing about notice after that. That's my recollection.
It certainly did that for the tortious interference claim for Kawamoto. It denied that portion of the motion for personal adjournment because of the lack of notice. So there was that as well. And also, just, Your Honor, that these facts should be viewed in the light most favorable to the non-moving party. And so where there's a muddled record, where there's facts and evidence that go both ways and admissions that go both ways, that should be given to the benefit of the Chastleton. Thank you.
Thank you, counsel.
Morning, Your Honors, and may it please the court. My name is Ian Thomas, and I, along with my partner Tracy Buck, represent the appellees Kawamoto Notes LLC and RFB Properties 2 LLC. We ask that this court affirm the decisions of the trial court granting partial summary judgment in favor of the appellees and ordering that the parties go to a foreclosure sale closing on what should be a relatively simple and straightforward transaction. We ask this for three reasons. First and foremost, from a procedural standpoint, most, if not all, of the arguments that are raised on appeal were not properly preserved below.
Can we just pause there? Let's talk about notice. That's their principal argument on appeal. That has been their principal argument throughout the trial court. Their whole complaint was we didn't receive notice of the sale. So in what way was that that was their principal opposition to the motion for summary judgment? The first one in 2018, I don't know why you guys got to file the second one in 2019, but forget about that because they raised the same point again in that one. Why is it not preserved?
So, Your Honor, this court has said time and again that it's not simply sufficient to say in a conclusory way, we dispute this, let's move on.
I mean, it's not sufficient to say it in a conclusory way if it's rebutted by something that's more than conclusory, but all you ever offered in terms of notice was a Washington Post newspaper ad, which does not seem to comply with the recognition agreement, and no specifics. Your complaint, your cross-claim, I should say, says we provided proper notice. Those aren't facts. That's a legal allegation. So what facts are in the record that you did provide the Chastleton with notice?
Well, the facts in the record and the law, Your Honor, established that we don't need to provide Chastleton with notice of the sale in advance.
Okay, so no facts in the record that you did provide them with notice, but it's now a legal claim that you did not need to provide them with notice. Is that right?
Pre-foreclosure sale, correct, Your Honor. So there is nothing in the record, the recognition agreement, the relevant statutes don't say that we have to provide a specific notice in advance of any sort of foreclosure sale or in advance of any execution on the collateral. The recognition agreement, as Your Honor touched on during opposing counsel's argument, does mention that after sale, before assignment of the collateral, notice has to be provided. And there are certain rights that flow from that notice, including potentially a right of first refusal.
So just to interrupt. Now you sounds like you're talking about a question of contract interpretation, whether or not the recognition agreement actually required notice pre-sale to be provided. Do we have a ruling about that from the trial court?
About whether notice pre-sale needed to be provided?
Yeah.
No, Your Honor, because, and this brings me back to the first point, which is that that argument wasn't cultivated in the trial court by the Chasleton. And
It
that's
was
sort of
very well cultivated, counsel. That was their complaint. It's the entirety of their initial opposition to motion for summary judgment. And I grant you, these are brief oppositions to motion for summary judgment. And in their second opposition to the 2019 motion for summary judgment, it's also the only thing they say in like their 5 or 6 paragraphs is we didn't know, we didn't know, we didn't know. I don't understand. Like they didn't cultivate, they could have done better. They could have explained it more, but they've also got an admission in the record at JA 279 that they point to, and I haven't heard a response yet, where RFB acknowledges that they didn't receive notice of the sale as required under the recognition agreement.
Oh, certainly, Your Honor. The problem with that is that it's kind of confusing the point. So those are two different things. So after the sale was completed, there was a transfer as part of getting the lender out of the case, a transfer of the stock certificate and the proprietary lease to RFB Properties. And in that process, those documents were executed. But that has to do with the notice of post-sale assignment to RFB and to a post-sale assignment to RFB of the stock and of the proprietary lease. It doesn't have anything to do with pre-sale notice, which isn't required under any statute or any
I'm
contract.
confused. I thought that the record materials contained an acknowledgement that no notice had been given. And you're saying this has to do with post-sale notice. Are you saying that there was an admission that there was no post-sale notice?
So I understand it's a little confusing, so let me walk the court through it very quickly. So in closing, in selling the collateral, the lender, former lender,
Let me just start here. Are you conceding that there was no pre-sale notice?
we're saying
As a
that
factual matter, there was no pre-sale notice.
the notice that was provided.
You've got a
with-
legal argument that it's not required, but as a factual matter, you're conceding there was no pre-sale
The
notice.
pre-sale notice that was provided would have been an advertisement in I think the Washington Times, I think you're honest, the Washington Post, the Washington Times, which is what would have been required. If you look at the UCC article, I believe it's Article 9, 228:9-610, there is no notice that needs to be provided to a co-creditor in foreclosing upon collateral. In this instance, it's not real property, it's shares of stock, so it's not governed by 42.815. It's governed by the UCC, and that pre-sale notice isn't required.
I take your point about the statutory requirement for notice, but their complaint throughout has been the recognition agreement requires that we be notified. I don't recall RFB ever arguing below, no, it doesn't. What RFB said in its cross claim is we provided proper notice in a conclusory fashion without any facts to support it. And sort of most troubling for us here on appeal is none of this has been engaged with by the trial court when granting summary judgment. I don't know how we could uphold a grant of summary judgment when their principal claim has been we weren't notified and we needed to be, and we have just no ruling on that whatsoever.
Well, candidly, the problem here, Your Honor, is twofold. RFB wasn't required to provide any sort of notice whatsoever.
Where was
It
that?
a
Where did you make
purchaser.
that argument in response to their arguments that you were required to give notice in the trial court? I know you've made it on appeal. At what point did you tell the trial court, in response to their oppositions for summary judgment, we weren't required to give them notice under the recognition agreement?
Your Honor, what the notice argument that was raised below is a cursory 2-line statement.
Should we start with their complaint? I mean, where do you want to begin with how many times they raised the notice argument?
Well, Your Honor, it's not necessarily that it is in their complaint, but it was in their opposition to summary judgment at a certain point.
It's the crux of their complaint. It's the crux of their 2018 opposition to motion for summary
Yep.
judgment, which you want to skip to the 2019 one because that's even briefer. But even in there, it's notice, I think 5 or 6 times.
Well, I understand, Your Honor. The other thing that I think is important to point out is that the original complaint was brought both against RFB as the foreclosure purchaser, but probably most important and most material to what Your Honor is focusing in on, it was also brought against the lender who conducted the foreclosure sale, who CHASTLETON did voluntarily dismissed with prejudice. So by dismissing with prejudice the party that conducted the foreclosure sale, they have adjudicated their claims about notice, because that would be the party that would theoretically have to provide notice if notice had to be provided in the first place. So they've adjudicated that point. That point was adjudicated in October of 2019 when granted, not opposing counsel sitting here, but the former counsel in the trial court dismissed the lender with prejudice, and that's found at A9 in the record, Your Honor.
So your argument is that they are stuck with the recognition agreement so far as it limits their right to recovery to 3 months, but they cannot enforce the recognition agreement's prerequisites to a sale because they dismissed Bank of America from the case?
No, not at all, Your Honor. I think they are entitled to enforce the recognition agreement's rights. I just don't think the recognition agreement provides the right to notice prior to sale. I think it provides the right to notice prior to assignment of the security.
And I want to ask one more time. Did you make that argument before the trial court, and can you point me to where?
I don't think it was raised that in that level of detail. It wasn't really raised before the trial court, Your Honor. I believe that for a form of it or an offshoot of it may have been in our filing, but that argument wasn't really raised. The primary argument that was raised in particular to Kawamoto, who's standing in the shoes of the lender as the note holder, it's not really a proper argument to make against RFB, because RFB is the purchaser. They're not the person that actually conducted the foreclosure sale. Kawamoto, who stands in the lender's shoes, could theoretically be the person that, or the party, I should say, that is subject to an argument about notice. But as Kawamoto did argue that they were the holder of the note endorsed in blank, and they were entitled to enforce the rights of the recognition agreement. And as an offshoot of that, one of the rights of the recognition, or the recognition agreement, does not provide a right to pre-sale foreclosure notice, or pre-foreclosure sale notice, I should say.
The arguments may not have been developed to this level of detail, but do you concede that it does contemplate post-sale pre-assignment notice?
Yes, I do concede that.
And do you dispute that that was not provided?
I actually, sorry, Your Honor, the dispute that was not provided. I think opposing counsel conceded when he started speaking to the court that they were aware post-sale of the actual sale.
My question is about post-sale pre-assignment.
Correct. Yes, they were entitled to post-sale pre-assignment
And
notice.
my question was, do you think there's evidence that post-sale pre-assignment notice was provided beyond publication notice?
I mean, they were certainly on constructive notice, Your Honor, because the assignment that they point to, which is the one where they acknowledge that notice wasn't pre-sale provided, was executed after the lawsuit had been instituted. So it has already, the parties were already aware of kind of what had transpired at that point in time. So there may not have been a formal written document saying, here, this happened, but certainly all parties were on constructive notice as to what transpired and how that sale occurred. But approaching back to this notice requirement, I want to point the court to its decision in Wagner versus Georgetown Medical Center, because I think it's an important point. In the Wagner case, this court said that even articulating an argument in a footnote of a pleading is not sufficient to preserve it. So when we look at the filings on the motions that are up actually before the court on review, I believe there's 3 lines that talk about notice without any sort of articulation. And as I think what we're demonstrating here is there are different forms of notice in this transaction that needed to be provided at different times, and simply just saying notice without any sort of articulation as to which precise notice you're talking about was deficient.
All right, I'm going to point you to their opposition to the 2018 motion for summary judgment at 859 Disputing the notice point, they say upon information and belief, Bayview failed to give requisite and prior notice of the sale to the plaintiff, failed to comply with the recognition agreement, did not have possession of cooperative shares, et cetera, et cetera. That's a paragraph 2A. Paragraph 9. The seller did not send proper notice of the sale to all parties in interest and entitled to receive such notice. Next paragraph. Now I'm at 9A, 9B. I don't know. I mean, I don't know how many times I need to, how many different times do they have to say it for it to be enough, do you think?
Your
I mean,
Honor,
they said it a lot is my point.
oh, I don't disagree, Your Honor, that they said it a lot in a prior motion that was denied, which order is not before this court on appeal.
Why did you get to file the second motion for summary judgment? I was curious about that.
The parties filed this, I was not counsel at the time.
I'm just curious. Usually leave of court is required and no leave was provided. So I was curious why a second one was filed. But okay, so you want to look only to the second motion for summary judgment.
The one that's
So-
before this court, Your Honor.
Right. So we can skip ahead to that part of the joint appendix and let's see what we've got. Chastleton opposition. So at paragraph 2, the fees described were to be paid to plaintiffs. Said note was sold without plaintiff's knowledge that these are the facts. That's not what I wanted to look at. Ms. CPEC was held in default without plaintiff's knowledge. The circumstances surrounding the sale or dispute. Plaintiff is with knowledge that defendant RFB was a successful bidder, but it was bought directly from the bank and plaintiff was not notified. Why isn't that enough?
Well, it's first of all, it's factually inaccurate, Your Honor. RFB never bought the note directly from the bank.
Okay.
Kawamoto is the one that bought the note from the bank. So it's not noticed that they didn't get pre-foreclosure sale, a pre-closure notice.
Paragraph 5, this is just the next paragraph. There's not that many of them and all of them seem to be noticed. Plaintiff disputes defendant's assertions surrounding the closing of the sale because the sale was not valid given the fact that plaintiff was never notified of the same. Why isn't that good enough?
It may be to preserve it. We just don't believe that it has been properly preserved. The point being though, Your Honor, is that even if it was, the recognition agreement nor any statute requires them to get notice pre-sale.
Yeah, that's something we just don't have a ruling on. That's something that we don't have a ruling on, and I don't think you raised it in the trial court, and you have yet to point me to where you did. I've asked you, where is the argument in the trial court that you weren't required to give pre-sale notice? That pre-sale notice was not, I shouldn't say you, I mean, B of A initially, and then I guess RFB. The pre-sale notice was not required. I didn't see it. I'm asking for it. I'm not hearing an answer to where that was ever made. If it was made, that's a legal dispute about contract interpretation, which is somewhat factual. I would think the admission at JA 279 would be relevant to it, and I would think we would want a trial court's ruling on it, and we could say, well, there can be disputes of material fact about contract interpretation, right?
Well, yes, Your Honor. Ultimately, the ultimate decision is going to be a decision of law, but underlying facts certainly could exist on that.
The parties' shared understanding of what it
As a
meant.
general proposition, I agree with that, Your Honor. I see my time is up. If the court has any more questions.
I guess I'm interested in your response to your opponent's argument that at least as a cross claimant, RB Properties is really a stranger to this litigation now. It may still be a proper defendant, but if any right or interest it had in the properties at issue or property interests at issue were assigned to RFB, the individual, what is it that makes you think your client is a proper cross claimant?
Certainly, Your Honor. So I can address that in, I think, 2 points. First, not to harp on preservation, but again, that was not an argument that was raised below in the briefing that RFB is not a proper party to this. It was absent from any of the oppositions to summary judgment.
And do you think that that's an issue that might go to standing in a way that might be jurisdictional and thus that the court would need to consider? I mean, if all of a sudden in the middle of an appeal, there's a realization that one of the people whose party has no interest in the matter, the court might, even if the issue hadn't previously been noticed, have obligations of addressing that topic. Or do you not think would be the kind of standing issue that would require sua sponte consideration by the court?
So I don't, Your Honor, for two reasons. It actually leads me into my second point, which is Rule 17 expressly states that you can bring a claim on behalf of someone who's a beneficiary of the contract. And what happened here, and I think it's highlighted in the briefing to some extent, is that the bylaws of the Chastleton require that the holder of the share certificate be an actual individual person, not an entity. And so Russell Brown is the managing member, sole member of RFB Properties 2. He was going to take the assignment at closing. And so it would ultimately, the closing would be for the benefit of him, RFB Properties though, because we haven't gotten to closing because Chastleton would refuse to go to closing. That assignment right never really vested. But I think that harkens back to point number one, which is that because that was never cultivated below, it was waived. There is no, I think, standing issue that would prevent the court from entertaining the arguments. Because Rule 17, I think it's 17A4, but I don't have my.
Talk about the Superior Court civil rule?
Yes, correct. States that you can bring, and it's cited in our brief as well, Your Honor. States that you can bring for the benefit of someone else. And in this instance, it would be RFB as has the contractual right to purchase that will be assigned at closing to its owner because it's the only person that can actually take assignment or have the share certificate, I should say, issued in its name.
Does Rule 17 contemplate disclosure, though, in the trial court so that people are aware that you're not bringing the claim on your own behalf, that you're bringing it on behalf of someone else?
Certainly, but I think that is kind of implicit in the counterclaim. And it's pled in the counterclaim for the purpose of putting everyone on notice as to what exactly is transpiring.
Thank you, counsel.
Thank you, Your
We'll
Honor.
let you sit down. Mr. Goki, we'll have you up back at the podium for just a couple minutes.
Thank you, Your Honor.
Thank you.
I think one of the reasons this got conflated with the order was because in the initial order denying summary judgment, Judge Jackson, towards the end of it, talks about it is clear to the court that the recognition agreement does not limit plaintiff's lien for sums due to only 3 months of special assessments. And I think the appellees did a very effective job in their motion for reconsideration, seizing upon that and pointing out that that wasn't the focus of the case. And although many of the arguments we talked about today were argued in front of Judge Jackson, they were not argued in front of Judge Scott. And at one of the status hearings, Judge Jackson had said he was going to issue a clarifying order, and then that order never came from the court, and then Judge Jackson retired. And so when the case was then transferred to Judge Scott, again, I think appellees did an effective job of seizing upon this 3 months of special assessments as the erroneous part of what they thought was Judge Jackson's mistake. We believe it was error for Judge Scott many months later to then focus on that and to reverse the order for all the reasons that we've set forth in our briefs.
Yeah, I mean, although, there's a lot of not preserving things going on in this case, including that when they filed a motion to reconsider and to grant summary judgment because of Judge Jackson's error, your opposition for reconsideration never says one word about notice. It doesn't say it kind of rolls over. So, I mean, I can certainly understand why Judge Scott, in granting summary judgment on reconsideration, did not say one word about reconsideration, did not say one word about notice, and it's because the opposition to reconsideration didn't say one word about it. I mean, I don't know exactly how that dust settles, but there were certainly a lot of arguments at a lot of times that Chastleton had available to it and was making sporadically, but not making at every turn, and that might be held against it.
I guess I would say that I don't disagree, Your Honor. In fact, I agree, but again, this is summary judgment, and even where arguments weren't robustly made below, the court, this is a de novo review. The court does have the discretion to consider the record to make the judgments that it thinks this gets to the correct result. And I would just ask the court to consider the whole body of the evidence that is before it. And again, viewing that information in the light most favorable to the non-moving party, to the Chastleton. And we think that with a thorough review of the evidence, the record that is before the court and the arguments that were made and the notice that was not provided to the Chastleton, this should be reversed, remanded, sent back to the Superior Court for the proceedings. Thank you.
Thank you, counsel. We appreciate your arguments today. The case will be submitted. The next case on our calendar today is 23 CV 492 and 23 CV 669. Sarah STAAB versus Wells Fargo Bank.
Please the court, Robert Gill on behalf of the appellant Sarah STAAB. This
Counsel,
case,
can you let us know how much time you'd like for rebuttal?
yes, ma'am. I'd like to reserve 3 minutes for rebuttal.
Thank you.
So this is another foreclosure case, different than the one before you, because this one involves real property and not other property. And, you know, this is a condominium association foreclosure sale, which gave rise to the issues in this case. There's a competing claim to the property by Wells Fargo Bank, who owns or owned a mortgage on the property. And the issue is, what is the right of Wells Fargo with regard to the property, and what is the right of Ms. STAAB with regard to the property? Ms. STAAB purchased the property at a condominium association foreclosure sale, where the condominium association foreclosed on its lien for unpaid assessments under the DC Condominium Act. And as I addressed in my brief, and as this court knows from its prior authority, the lien of a condominium association can be a first or super priority lien that would jump in front of the lien of even a purchase money deed of trust. The issues in this case are a little unique because Wells Fargo, not in its original complaint in this case, the original complaint was a single 1-count complaint for judicial foreclosure, alleging nothing other than the borrower failed to make payments on the mortgage as required. And the borrowers went into default on the mortgage in the summer of 2011.
Counsel, we're familiar with the facts. I mean, you say this case is unique, but I'm wondering how unique it may be, given that Fannie Mae and Freddie Mac have interests in many mortgages in the United States. So this actually seems like this might be a precursor for a sea change in our law. We do have our condo lien statute, but then there's also the federal statute and the federal foreclosure bar. So that's where we are now, right? But that's not really, we're not here on the merits, I think.
Well,
You have claims of whether or not Wells Fargo should have been able to amend its complaint. You've got a statute of limitations claim. You've got an essential party claim. So maybe we should just jump right into those, given the time constraints that we
sure.
have.
So with regard to Your Honor's observation, though, about a potential sea change, the facts of the case are a bit unique. So, for example, there's a tale of two cities between the facts of this case and, for example, the M&T Bank versus Brown case, which was in the United States District Court here in DC, which addressed issues cited in the briefs with regard to the federal foreclosure bar and the rights of the the government with regard to the mortgage. The difference is in the M&T Bank versus Brown case, the bank there did everything right. So there was a foreclosure sale at condominium association, and Brown was the buyer. Brown bought the property foreclosure sale. And the bank that had a lien on the property, a mortgage lien on the property, then brought suit to foreclose on its mortgage. But it did so promptly. It did so about 6 months after the foreclosure sale to Brown in that case. And they also joined the Federal Housing Finance Administrator as a party to the litigation. So there was no question in the litigation about what rights the plaintiff bank had with regard to the federal foreclosure bar and the HERA legislation. Those aren't the facts here in this case. In the Brown case, the litigation was brought promptly within 6 months, so there was no statute of limitations issue. In this case, there is a statute of limitations issue because one of the issues is what is the statute of limitations that applies to the claims that are asserted by Wells Fargo Bank based on the federal foreclosure bar. There is no privity between Wells Fargo Bank and Sarah STAAB. Sarah STAAB acquired her interest in the property from the condominium association. So there's no privity between her and the bank. So she was an innocent purchaser. And despite a suggestion in the amicus brief in this case, and Ms. STAAB had knowledge that this loan was owned by Federal Housing Finance Administrator, there is no evidence in the record of that at all. There was no allegation that she did below. There's no evidence of that in the record. I would challenge parties to be able to show that. So she acquired this property without knowledge of any interest by Fannie Mae in the property. So she acquired the property at a foreclosure sale.
Is that right? Of any bank? I thought that I may be confusing the two cases, but what did the notice of sale say with respect to the extent to which she would take subject to prior liens by banks?
No, I understand what Your Honor is referring to. There was a statement with regard to the advertisement and or the memorandum of sale, but as you know, under
I'm well aware of it. I just was wondering about your statement that she bought the purchase without any awareness of the interest of any bank. That seems to me not
with regard to Fannie Mae, different than Wells Fargo.
Okay. Well,
so
yeah,
I'm drawing a distinction.
You mean without any awareness that a federal bank that might have the ability to assert a federal foreclosure bar was
Absolutely.
That I understand. I thought you had said any bank, and that's what threw me.
No, there was, and there's often a mortgage lien on a condo when the condo goes to foreclosure sale, which is how we got the Chase Plaza line of authority that addressed this issue. And what is the authority, what is the priority of the lien with regard to foreclosure sale? But in this case, if you look at the timeline, the mortgage, the borrower for Wells Fargo was a gentleman named Sutcliffe. And Sutcliffe defaulted on his mortgage in 2011. And as a pattern that we see in these cases, Sutcliffe also started failing to pay his condo association.
And again, we're familiar with the facts. I'm really interested in hearing your arguments. So yeah, I thought you were going to make a statute of limitations argument, but I haven't heard it yet.
Well, I am, and this is the factual predicate for the argument. So the foreclosure took place in 2013. There's a state court statute of limitations for claims to set aside a foreclosure sale. If you want to allege that foreclosure sale is wrongful, it's a 3-year statute. And the statute begins to run and the claim accrues at the time of the notice of closure sale, which is 2013. So there would be a 3-year.
Was count one of the original complaint timely even under a 3-year statute of limitations?
With regard to the foreclosure sale, it would have been yes.
And what is what does that mean? So if you were correct, the counts 2, 3, and 4 of the amended complaint, if I'm getting the numbers right, would fail for statute of limitations reasons, but count 1 would survive. What is the practical implication of that in terms of what legal rights people might have under that count? And so I'll be more concrete about that. So that count, rested on a mistake of fact about who owned the loan. I understand that. But its structure was, we own the loan, speaking very roughly, and there's been a default and we have a power of sale. And so we want a foreclosure sale.
Right.
And it acknowledged that Ms. Staub was a purchaser, but didn't really explain how she came to be a purchaser.
Exactly.
So that's the first count. I get that.
Exactly.
So if that count is timely, then the way it would spin out would be if your client would say as a defense, well, you can't foreclose on this. I already did, and I extinguished your rights.
Exactly.
I get that. And then Wells Fargo would say, well, you thought you foreclosed on it, but that foreclosure was invalid. Your defense is not good. And why the reason it's invalid is because there's a federal foreclosure bar. So how do we get out of any of these issues if counts 2, 3, and 4 are foreclosed? And if so, why?
Yes, because count 1 in the amended complaint and the original complaint only sought to foreclose on the mortgage that was granted by Mr. Sutcliffe. And if you look at the original complaint, there are 0 allegations in that complaint with regard to the foreclosure sale at which Ms. Shaw purchased property.
I understand that.
So there's nothing in that count that really implicates her. It's just seeking to foreclose on the mortgage. It doesn't address the other issue, the elephant in the room. What do we do about Ms. Staab's interest in the property? Now,
The reason I'm asking is it seems to me, at least arguably, but nobody's ruled on any of this, so it might be something that had to be sorted out on a remand if you were to prevail on aspects of your statute of limitations claim. But it seems to me that leaving aside again the complicating factor of the mistake of fact about who owned the loan, that is a somewhat confusing, complicated factor. But if it's not clear to me, I guess, that Wells Fargo would have to anticipate these defenses. They can just come in and say, arguably, they can come in and say, imagine they'd understood everything. And the way they framed their complaint was, we are the successor of the lender. We have, there's a default. We have a power of sale. We want a sale. That looks like a good claim, arguably. And then someone who had already, if there already had been a judicial foreclosure that would extinguish such powers, then the party who wanted to defend on that ground would say, no, wait a minute, here's my answer. That what looks like a good claim is omitting something that has extinguished the rights that you're asserting. And then they would interpose as a response to the defense, well, you thought you had extinguished our claims, but the federal foreclosure means that you didn't. And so the remedy we want is an actual legitimate, lawful, not preempted foreclosure sale.
I respectfully disagree with your comments because there is an obligation by the plaintiff to assert a plausible claim. And by failing to allege any facts with regard to the circumstances under which Ms. Staab acquired title to the property, no plausible claim against her has been asserted at all. And even worse, the bank comes in later and asserts its federal foreclosure bar argument. The bank, and picking up on a comment Your Honor made in the first argument in this case, the prior case, the interest of the Federal Housing Finance Agency was never disclosed in the original complaint. So they're the real party in interest. Their interest wasn't disclosed, it was concealed. And an allegation to the contrary was made, which was Wells Fargo owns the note and Wells Fargo owns a deed of trust. And there's an implication is there's no other party in interest. And they had an obligation to assert a plausible claim against Ms. Staab and they didn't. But in furtherance of your comment, Judge, we did in our answer assert a claim under Chase Plaza that the condominium association foreclosure extinguished their interest. This is before we heard anything about federal foreclosure bar or Federal Housing Finance Agency having an interest in the property. We didn't hear about that until 2019. So the question is, with regard to a claim by Wells Fargo to try to set aside this foreclosure sale, what is the statute of limitations that should apply to the claim? And I think it's a 3-year statute, 3-year statute for claims not otherwise specified under the DC code. The claim would, or a claim for wrongful foreclosure, which is a 3-year statute, which would accrue from the date of the notice of foreclosure sale in 2013. So the claim would have accrued in 2013. It would have expired in 3 years. By 2019, that claim is stale. The amendment was made after the statute ran.
Can I ask you, you're focusing on the statute of limitations point, at least what you mentioned thus far seem to be DC statutes of limitations. The federal provision, there's a federal statute of limitations provision. And are you arguing that, I take it you're arguing, I mean, that seems like it's a first step, is to see what does the federal provision provide? And it has a 6-year provision for contract claims, which your opponent relies on.
Yes.
I take it you're relying on the idea that this is really a tort claim of wrongful foreclosure, and therefore, as a matter of federal law, it's subject to 3.
That's exactly what I argued in my principal brief.
And then the state law comes in because this federal provision also says that longer state law provisions can be relevant. And then you're arguing, so you have to be kind of 3, both federally and as
Yes,
DC
yes.
law in order to prevail. Is that right?
That's exactly right. So that's why I did both, because I needed to be able to show, under either statute, I think it's untimely. And, the bank should have been given leave to amend. The bank didn't have good reason for waiting until 2019 to assert its claims. The record establishes that the factual and legal basis for its claims existed at the time of the default in 2011. So by the time it filed its original complaint in 2015, it could have asserted every one of these claims, but it just didn't, failed to. And so
I'm still kind of hung up on Judge McLeese's question, which you said that the first claim, kind of, we want a foreclosure by the bank.
Right.
That is timely, even under a 3-year statute of limitations when it is brought in 2015. Am I getting the years right? So,
well,
and so I'm still, at some point you said something about staleness. I'm still not following, again, going back to what Judge McLeese said about, well, you say we want a foreclosure. Ms. Staab comes back and says, no, we already had a foreclosure.
Right.
The bank says, no, that foreclosure wasn't valid because of the federal foreclosure bar. Like, why can't it play out that way
well, the problem is.
and still be timely?
The problem-
Yeah.
The problem is, we're entitled to a plausible complaint to assert claims against us. So we know really what the nature of the claim is. By failing to assert a cognizable claim against Ms. Staab, we don't know what the theory is behind the claim. And without knowing the theory, we don't know what statute of limitations would apply to the theory. And without knowing the statute of limitations and the theory, we don't know what the accrual rule would be with regard to the claim. So it's a game where there are no rules to allow a plaintiff to come in and add an additional party to a claim.
Can I ask you, just to complicate this even further, I had been focused on the wording of the count 1 in the original complaint.
Right.
The amended complaint has, corrects the factual error about who the owner of the note is.
Yeah.
And it has in it material that does relate to some of these matters.
Yes.
Now, I know there's a question about whether counts 2, 3, and 4 relate back.
Right.
And, which is another complexity.
Right.
But with respect to the revised version of count 1 that you find in the amended complaint,
Right.
do you think that would relate back, or do you think it would not?
Not as to Ms. Staab, it wouldn't. I mean,
Not as
it would-
to,
not as to Ms. Staab, it shouldn't relate back. They're alleging new allegations with regard to that claim that we couldn't reasonably anticipate based on the original complaint. There are new facts. I mean, we never.
why is that? I guess I get the idea that you couldn't foresee the federal foreclosure bar response to your defense.
Right,
So I get that.
right.
So there was the complaint didn't provide, the original complaint didn't provide information that would give you notice about a possible impediment or response to a defense that you could predictably have been expected to interpose to the complaint.
Exactly.
And do you think a complaint normally needs to include allegations that would allow defendants to predict what responses will be made to defenses that they can predictably raise to the claim? Right? That's where I start being
No,
unsure.
I think the obligation of a plaintiff to plead a plausible claim includes the obligation to plead a claim that's plausible enough to allow a defendant to assert
I
a
get that. I
defense.
thought that's a Twombly Iqbal dismissal argument, not so much a statute of limitations argument. Nor is it so much a relation back argument. So I get that separate line of thought, which is maybe the first claim, if it had not, should be subject, if you were looking at the first claim as originally phrased, maybe it would have been subject to dismissal on the merits or failure to state a claim. I get that. But I'm not quite sure how that
But
relates
to answer your
relation back.
question, if it weren't for the new federal foreclosure bar arguments, I think count 1 would have been fine. The problem is count 1 is now predicated on those new facts and a new party we never heard of that wasn't raised till 2019. That's
I guess where I'm hung up is I'm not sure it's predicated on it. it's predicated on the idea that they're, you know, that they have an interest that gave them a power of sale. That's what it's predicated on. Then there's a defense, which is, oh, well, that would have been great, except there's already been a foreclosure sale that extinguished your rights. And so it's not so much predicated on it in stating itself as a claim. It is subject to a defense, and there's an answer to the defense.
Well, I respectfully disagree, and here's why. Before, the context for this was state law, lien priority issues. I can grapple with those, and I could grapple with those from the original complaint, even though I thought the complaint was deficient. And you will note I raised as an affirmative defense the original complaint, failed to state a claim upon which relief can be granted. But what really changed the landscape entirely is the new overlay of the federal foreclosure bar claims. That's what changed everything for us. Disclosed a new real party and interest. It disclosed a new statutory scheme, and it implicates all these additional issues. So as I was saying earlier, one is, what is the statute of limitations would apply to the claim? And clearly there's no privity between the bank and Ms. STAAB. So it's my position that it's not a contract statute of limitations. It is a court statute of limitations, which would be a 3-year statute. If there were a 6-year statute of limitations to be applied, when would it accrue? With regard to the claim against Sutcliffe, it's clear that that would accrue from the date of his default in the mortgage, which was the summer of 2011. When would it accrue as to Ms. STAAB, who's not in privity with the bank? There's no yardstick we can use.
The date of the foreclosure sale.
Well,
The thing that presumptively extinguished their lien under DC law. Why isn't that the yardstick?
well, but then it's not a contract claim. Then it's a different claim.
Well, I
And
mean,
that's
I
my-
agree, but nobody says, you know, a lot of federal courts have grappled with this, a lot of Nevada
Yes.
courts have grappled with it.
Yeah.
None of them say it's a contract claim. They say it's a weird thing. We need to match it.
Right.
To, is it more like a contract claim or is it more like a tort claim? And because what they're doing is they're asserting an interest under a contract to recover some money.
Right.
That's more like a contract claim than a tort claim. And, you know, they're seeking damages that are calculated according to the terms of a contract of how far these debts have ballooned over time. It's not like a torts damages type of inquiry. And so it feels, you know, the rough gist of it is this feels more like a contract claim is the argument.
That's exactly my point. With regard to the bank's claim against Sutcliffe, it is exactly a contract claim. There are written agreements that define what the rights and remedies of the bank are, what it's entitled to recover. So there is a clear defined basis for the claim. None of that exists with regard to Ms. STAAB with regard to an alleged contract claim. We don't know when the claim would accrue. Again, you know, why would it be a later accrual date than the accrual under the contract with regard to Sutcliffe if she's being sued on the same contract? Why wouldn't it accrue the same time he defaulted under his mortgage? That should be the accrual date. Why would there be a separate accrual date? That to me doesn't make logical sense, but it's an example of the difficulty of trying to put a square peg in a round hole and figure out, you know, which tag we put on this claim. But I think at the end of the day, it is, in essence, it is a competing claim for priority. It's not a contract claim. It's a 3-year statute claim that like would apply to a claim to quiet title, which is one of their claims, claim to quiet title. I think it's a 3-year claim. And it's as of the date they knew. And when did they know? They knew based on the facts in the record that are undisputed. Sutcliffe defaulted on his mortgage in the summer of 2011. And within a month, the condo association filed its first of many liens against the property based on unpaid assessments. So the bank had constructive knowledge of a problem with regard to the default and interest of the condo association as of then. So should they have done something? Well, clearly they should have. You know, I mean, they were obligated under their servicing agreement with Fannie Mae in order to pay real estate taxes and pay assessments. They paid the real estate taxes. They didn't pay the assessments. That's
So,
why.
sorry, I'm just keeping track of dates. You're saying, now you're pointing back to Mr. Sutcliffe's failure to pay.
Yes,
And you're dating that to 2011.
yes.
And if there's 3-year statute of limitations, then are you saying that in fact, the 2015 complaint was untimely?
Well, if that is the accrual date for the claim against Ms. STAAB, then yes.
Did you make this argument below?
I made the argument below that It's not a 6-year statute of limitations, that it's a 3-year
Right, but
statute of
did you make
limitations.
the
And
accrual?
the accrual argument, I don't think was raised below. The accrual argument, I don't think was fleshed out.
Can I ask you, I struggle with whether, I mean, it does seem a bit of an awkward fit as to tort or contract, which is why and I
agree.
think courts have struggled with that as well. So just a simpler hypothetical, if I own some like unique piece of art and I enter into a contract to sell it to you, and instead of doing that, I sell it to someone else and you bring an action against me saying you breached the contract, you were supposed to sell it to me. And you also, name as a defendant the person who purchased it, and you argue that, under relevant principles of contract law, which might depend, the answer to that might depend on the circumstances. You argue that the sale needs to be invalidated and therefore that the property should be, the contract of sale to you should be enforced. Would you think of that action to try to cause the property to be sold to the right entity rather than the wrong entity is that more of a contract action? Do you think you're suing in tort for purposes of statute of limitations? Which do you think? Because this case seems a little bit like that in simplified terms.
The answer to your question is very lawyerly. I think it depends. So the party with whom you had the agreement would be a contract claim, but there's no privity with the purchaser. So you'd have to figure out another claim for the purchaser, and it's probably a tort claim.
Can I just ask you, why do we think that DC Code 12301A6, the 12-year statute of limitations for real property doesn't apply for recovery of lands, tenements, and hereditaments, if I'm pronouncing that correctly?
If-
15 years.
If there were privity between Ms. STAAB and the bank, I think you'd be right. But there's no privity. So there's no recovery. This is a warring battle of claimants as to who has a superior right.
But
there's
she possesses it, right?
does
I
possess
guess I'm not following. Why does privity play into this?
Well, because it's the recovery of land. So to me, the recovery of lands example applies where you have a mortgage, you have a lease, you have a license, you have some privity with the user, and you want to recover that which is yours, which you no longer have possession of because you have agreed to provide that to someone else under some basis, and you want to recover that. I think that's where that applies. But where you have two parties that are not in privity, I don't think that applies. So
I mean, that's sort of reading a term in it says recovery of land. It doesn't say recovery of land from someone with whom you are in privity. So it seems to be reading in a limitation that's at least not on the face of the provision.
well, to me, it's contextual. And we're grappling with how to apply these rules, which in many respects are not terribly clear. And the question is, how do you deal with it? How do you balance the equities and figure out what to do here? At the end of the day, one of the points that I'm left with is that Wells Fargo had the ability under HERA to be able to take steps to recover this property from Sutcliffe beginning in 2011, and it waited until 2019. And by waiting to 2019, it's severely prejudiced Ms. STAAB, who's an individual, who bought this without any kind of knowledge that she was getting involved in this lawsuit. And, that's where she is. The bank could have taken action to prevent this, and it didn't.
I get that, but
And now they want her to pay for it. And that seems to me to be inherently inappropriate.
can I just on your theory that the statute of limitations applicable to recovery of land turns on privity, if I understand it correctly, if you and I enter into a contract and I give you legal title to a land, to land, and I end up thinking that was a fraudulent contract in some way, and I file an action to try to get legal, title back. I want to have that transaction nullified. I want the land back. We'd be in privity, and I take you to be saying that there'd be a 12-year statute of limitations upon which I could proceed.
Well, we have to be careful. If you're alleging fraud, I don't think you have a 12-year statute. So
pick some provision, pick some basis other than fraud where I'm claiming a legal entitlement to rescission of the contract and recovery of the land. If that's throwing.
the examples that come to my mind as somebody who's done a fair amount of real estate litigation are the mortgage, the lease, the license, some agreement where you're recovering that which you voluntarily provided possession of to someone else.
You're talking about, you think it's recovery of possession rather than legal title? Is that what you're saying?
I think it's both, but I think it's both.
And, but however abstractly you want to put it, let's say that there is a cause of action I'm bringing against you. I entered into a transaction where I voluntarily gave you legal title and possession to land that I previously owned. I now have a cause of action where I'm saying, I want it back. I'm entitled to have it back. I take you that at least some of the time, that would be a 12-year statute of limitations.
Well,
Is that right or not right?
well, and this is why I'm hesitating, because that causes me to question, okay, now I need to look at the statute of limitations for, what is the statute that applies for adverse possession? So are they coextensive with?
Well, that's why I said
period?
at least, I mean, if it's not a nullity, there will at least be some
So-
scenarios that are not governed by.
Right, so I'm
other-
concerned about giving you an answer out of fear of the unintended
Yeah,
consequences.
I'm not trying to
doctrine
trick you. I'm really not trying to.
because of that.
Let me just tell you where I'm headed, because the thing that seems odd to me is assuming that there are some transactions that are like that are governed by the 12-year statute of limitations and not subject to other ones that might be applicable. Assuming there's at least something there. It seems very counterintuitive that I have 12 years to bring that action against you. But if you then sell it on to someone else, and I think I have a legal right that I have, like, it compresses my statute of limitations. Just seems like that would be an odd statute of limitations. It seems like a somewhat random, and if anything, you might think it'd be harder for me to run all that down. I just don't see why that would operate to compress my statute of limitations, why the legislature would want to do that. So it seems puzzling to me, the proposed limitation you're suggesting.
It seems to me difficult and odd to try to treat this as something other than a claim for competing lien priority on real estate, which is what it is. So I see my time is up. I'm certainly happy to answer further questions before rebuttal.
We'll let you sit down right now.
Thank you.
And we'll hear you on rebuttal in a little bit.
Good morning and may it please the court. Dan Herbst on behalf of Wells Fargo Bank NA. With me at appellee's table is Mr. Johnson on behalf of the Federal Housing Finance Agency. I want to just start with a point that I think was dispensed with earlier and make it clear for the court that the underlying merits issue of the preemption issue is not at issue for you. It was not placed at issue, and it was the substance of the summary judgment ruling below. But the only issues we're dealing with are the statute of limitations that we'll talk about. This indispensable party issue that we can talk about if the court is interested, and then also this leave to amend issue, which is a very high bar for him. It's an abuse of discretion standard. So nowhere in his briefs, in his opening brief or his reply brief, did he address the underlying merits of the summary judgment decision below.
Well, I think that's kind of a half truth. Because their argument is, well, sure, the federal act certainly prevents them to the extent the DC code allows a condo association to sell without the agency's consent. Federal law preempts that, right? That's undisputed. But I think their argument is that's all it does. It prevents the sale. And if all it does is prevent the sale, then the cause of action that is available to Wells Fargo and the agency is a wrongful foreclosure action, because what you're trying to do is say that sale was wrongful. So that's his argument. And it's not quite that it's not preempted, but it's a little bit like, well, it certainly doesn't preempt that if a sale goes through, it can extinguish other liens behind it. It's just that the right that Wells Fargo and the agency had were to prevent the sale and then to unwind the sale. And they say for a 3-year period of time.
I understand, Your Honor, that that's what Mr. Gill is arguing, and
It just strikes me as preemption adjacent, I guess it is my point.
I think that's fair to call it preemption adjacent, but my point was more that he didn't address that merits issue. But the issue of statute of limitations was addressed in the summary judgment ruling, and I'm happy to address that. Again, I think we start with the statute here, and the federal statute has a statute of limitations period that says it's the longer of 6 years.
But before we go, because I think it's relevant, I would like to touch on the preemption question.
Sure.
What conflict is there between the federal act and the DC code? I don't see one. What the federal act says is you can't sell without the agency's approval. DC code doesn't say anything to the contrary. It says if you sell, could be with the agency's approval, then the condo association retains the priority lien. It will extinguish all liens behind it. There could certainly be, the agency could consent to a sale and that would all be fine. I mean, I see them as being entirely copacetic. So what's the conflict?
I don't think it's a statutory preemption question, as I think you framed it, Your Honor, but it's an express or a conflict preemption issue under the circumstances here, where we have a foreclosure of a condominium lien under the DC Condominium Act. And the federal statute states clearly that a foreclosure sale can occur if it's a property of the Federal Housing Finance Agency is not subject to a foreclosure or a sale, which is exactly what happened here. I don't see any way to read those two statutes as in
But
line.
the DC code doesn't say anything different. So what? So yeah, they cannot sell. So they committed, it was an unlawful sale. Okay, it's an unlawful sale under the federal act. Nothing about the DC code says that it was a lawful sale. So they're in harmony and your client had a wrongful foreclosure action.
I don't know that it's a wrongful foreclosure action, Your Honor. And even if that is the proper way to define the claim, a foreclosure complaint was filed in this case in 2015.
Well, not a
Avoiding Mr. Staab.
wrongful foreclosure?
No,
What was filed?
It was a foreclosure action. I mean, I
But
think,
nothing that challenged the prior sale.
well, I think at the time, the law in DC was that the lien that had been reported by the condominium association said it was subject to the first lien mortgage.
But this is what
Until lien was
confuses me.
decided later.
This is what confuses me entirely. Why do you care what the law was in DC, right? If you're operating under the federal law and have the federal foreclosure bar, the law in DC could be anything, but it's not your concern because you had the benefit of the federal foreclosure bar. What it looks to me like from reading the record is that you didn't know you had the benefit of the federal foreclosure bar because you didn't realize that you didn't own the loan anymore.
Well, Your Honor, I think.
And I
Rest-
guess to put it really bluntly, I'm wondering why that's Ms. Staub's problem.
Well, it's Ms. Staub's problem because by operation of the federal statute, that sale couldn't occur without consent of the agency. And so at the time that she bought purported to buy the property in 2013.
Right, but how would she know? I mean, she could have made a calculated risk of, I don't want to buy a Fannie Mae, property under conservatorship because there are all these restrictions on foreclosures. How would she have known that? You didn't even know it, is my point.
Your Honor, truthfully, it doesn't matter who knew. Knowledge is not an element of the federal statute, which protects this important federal property. And this is not a Ms. Staub only issue. This is a global issue of the millions of loans held by under.
Right. I mean, I guess this goes to
Right.
the issue that we haven't really discussed, which is amending your complaint. But, as far as dilatoriness in amending your complaint, because the initial complaint didn't say anything about a wrongful foreclosure claim, you just asked for foreclosure. And then you waited several years and finally got around to saying, well, wait a second, actually, we've got a wrongful foreclosure claim. And that seems, like a factor that the court really didn't grapple with in exercising its discretion. And granted, it's an abuse of discretion standard, but if the court doesn't actually grapple with certain facts, that could be a grounds for reversal.
Understood, Your Honor. I mean, that issue came up extensively at the summary judgment hearing, and that's in the record where we talked about that with the judge below.
Right, and that's well after the complaint has been amended.
Right. I think the important point to realize is that Ms. Staub, took a calculated risk when she, made a bid at the condo lien foreclosure sale of only bidding $15,000 on a very expensive property a couple of blocks from here. I mean, there was a risk at the time, and the law was moving on both ends here in terms of the meaning and definition of what the DC Condominium Act meant for a condominium lien
Right,
purchaser.
she
as
assumed
well as-
all of those risks. She just didn't assume the federal law risk because she had no idea that Fannie Mae was in this game.
I mean, that's a risk she took. And And again, the statute that we're talking about, the federal foreclosure bar, doesn't speak to her knowledge or her risk. Whether it's an unfair result to Ms. Staub or not, is really not critical.
No,
under the federal
but
foreclosure
again,
bar. But I-
I'm refocusing the argument right now on Wells Fargo's ability to amend its complaint years later.
Well, it was 4 years later, and as this court is well aware, foreclosures take a long time in this jurisdiction. And Ms. Staub was was put on notice of the potential risk to her lien when a foreclosure action was filed, and she was joined as a party to that case. She was aware of the risk to that lien and to the potential
Right,
interest
and
in
she
her
was
property.
ready to fight that, and she stood ready, and she went through discovery, right,
And
for,
she did.
for 3 years, thinking that she was litigating against one claim. And suddenly Wells Fargo comes back and says, actually, we don't own the loan. We're just the servicer. Fannie Mae has the loan. It's under conservatorship, the federal foreclosure bar. I mean, a totally brand new set of facts.
I would argue that it's not a brand new set of facts. I mean, there are additional facts that were adduced in discovery, but
I mean, she could have, if she had known that in 2015, she could have opted to walk away, right? I mean, cut her losses and say, gee, federal foreclosure bar, I'm out of luck.
she could have, or she could have implied the.
But she had no
condominium
ability to do
association as
that
well.
because she didn't know and you didn't know, and you didn't say, and you didn't disclose until many years later.
Well, I mean, I think you have to look at the law of relation back and also look at the statute. to
Why would
discuss-
this relate back?
It's the same claim. It's a claim.
It's not the same claim. It's a
The
foreclosure claim versus a wrongful foreclosure claim
Well-
are two different
Well,
claims.
Mr. Gill has characterized this as a wrongful foreclosure claim. It's a quiet title claim. It's a claim over a dispute over lien priority. And that lien dispute priority was established when there was a filing of a complaint based on a competing mortgage interest and a competing interest in the property based on the condominium lien sale. That issue was
that
initially.
sounds artificial to me because, you stood up here a few minutes ago and you said the sale was invalid under the federal law. I totally agree with that. But that doesn't sound like a question. The federal law doesn't say anything about what happens after a sale and which loan gets priority or not. Federal law says you can't do that sale. You can't make that sale without the agency's consent. Why isn't that a wrongful foreclosure claim? I mean, it sounds like a quintessential, the previous sale was invalid. And this comes up in the trial court's order. The previous sale was invalid. And if that's the right way of thinking about it, it's hard for me to see why it's not a tort and time bar.
Well, I think the way to think about it is to, again, go back to the statute and go back to the way that here has been interpreted and its statute of limitations has been interpreted. There is a longer of is the instruction from Congress there, and that provision has been interpreted to be as expansive as possible to protect federal assets that are under conservatorship. So the argument that we should take the lesser of or the lowest possible statute of
Well,
limitations.
it's not take the
even
longer
though-
of
because
no
it
matter
may be-
what. It's not apply the contract statute of limitations if it's
Right.
truly a tort, or apply, you don't do that. Then you would just get rid of the tort statute of limitations and you would always apply 6 years. It's apply the longer of which one this claim can be fairly described as. And I understand federal courts seem to take a presumption in favor of the longer one. I'm not sure if that's from the statute or why that would be binding on us. I don't know if our case law has a similar presumption. Maybe you'll tell me if we do. I haven't seen one. But to me, I think, and the way the federal courts analyze it is, what does this look more like? And the federal courts have almost uniformly said it looks more like a contract. I just don't see why. I don't see why your claim and why the federal law doesn't say you don't get to sell this. It doesn't say anything about priorities. You don't get to sell it. So that day that they make a sale, they have committed a violation of the federal law that would prompt a wrongful foreclosure action. And that's a classic tort. So where am I missing? Like, what's my misstep in that thinking?
The right accrues based on the federally protected contract right under the deed of trust here. That deed of trust is the basis for the claim. The fact that there's no privity of contract, as Mr. Gill has argued, doesn't go to, as you know, all the courts that have looked at this have said, this is a right arising from a deed of trust. This looks more like a contract claim. We think we should apply the longer of. And that's what the DC courts below have done so far. And then the federal courts, both in the Ninth Circuit and in Nevada, have done that as well. And I think it goes to Judge McLeese's point where, you have a contract. We have a contract with our borrower who has a deed of trust. The borrower defaults and we have a right to enforce that. Now, the fact that the lien was purportedly sold out from under us through a condo lien sale that was in public record, subject to our lien, shouldn't change that contract right, whether or not, the court wants to characterize it as a wrongful foreclosure or otherwise, because it really, the right that's being enforced here arises from the contractual right under the deed of trust.
Is it, so, I mean, are you suggesting that what statute of limitations applies to a foreclosure, a wrongful foreclosure type claim, where the request is to try to unravel a foreclosure, that's the requested relief, depends on the source of the right that is the predicate for the claim. So that if the party who's alleging wrongful foreclosure is alleging it is wrongful in virtue of the contract that created the property interest that was foreclosed upon, then that's more contractual in character and should be viewed that way. Whereas if the claim of wrongful foreclosure is rooted in some non-contractual rights, let's say, someone who's a tenant gets foreclosed, and the argument is the procedures were not lawful under the procedures of local law about how to conduct a foreclosure, that's more of a tort claim and you'd have a different standard review. Is that what you're suggesting? Or I'm just not quite sure.
I think you're putting your finger on kind of where I'm suggesting, because the fundamental right here that's being enforced by Wells Fargo is based on this deed of trust, and it's a right under contract. There's also this federal piece to it that's where the statute says the longer of period, 6 or 3 years. Now, Mr. Gill has made this sound like a wrongful foreclosure claim, but this is not, we're trying to assert our right here. His wrongful foreclosure claim is a defense, he's essentially raising a defense that our foreclosure can't proceed because of his lien right. So it's really a competing lien right issue. And lien rights are matters of contract. And we've cited cases where there's, competing interests in land can be 15 or 12 years, but
as we know from Chase Plaza and its follow-ons, it's also a matter of statute. Because whatever the contracts try to provide, there's, the DC law has been interpreted to impose some pretty significant constraints on the party's freedom of contract in that area.
What I don't hear you talking about the other part of the federal statute regarding statutes of limitations, which says that it's for a contract claim, the longer of 6 years beginning on the date when it accrues, or the period applicable under state law. And similarly, in the case of a tort claim, the longer of a 3-year period beginning on the date it accrues, or the period applicable under state law. Are you not making a state law statute of limitations argument?
I am, Your Honor, and I think we would say that, again, the longer of, so we don't pick like the shortest period of time. And I think, as I said, I think all the courts that have looked at this have said it sort of feels more like a contract claim. And so, I haven't found any contrary authority that supports Mr. Gill's argument that this is really a tort claim. But, in looking at the DC state law and
Right, but even if we were to consider this to be a contract claim, we'd have to decide perhaps which statute of limitations applies. Is it the 6-year period, or is it the period applicable under state law, right?
I think under either.
I mean, I understand that you're saying we'd be fine with either,
we have to win one of them.
but arguably we would have to decide. I suppose we could hunt, but sometimes we like to be clear about these things.
Understood. And we've also raised an argument regarding.
So I'm not hearing any robust defense of a state law statute of limitations. You'd just like us to go with the federal 6-year provision.
I think, that was the ruling below that the federal 6-year applied. But I think if you look at the state law claims here are akin to more like a 12 or a 15-year disputes over land, ejectment issue. So under either issue, we win.
So you think 12-301A6 applies?
I think that I'm not exactly sure what provision that is from my notes.
That's the one that I was discussing with Mr. Gill when he was about the recovery of lands.
Yes, Your Honor. I think that is one of the range of claims that could apply here. And so under, there's so many options for the court to affirm on statute of limitations. He basically has to win on like 5 different issues, and based on the deference to the court below and the ruling, since the statute of limitations is really an affirmative defense that he has.
We wouldn't defer to the trial court on a statute of limitations issue, right?
I
That's
understand
legal
it's a de
question.
novo review,
Okay.
Your Honor. I was not making that argument.
Okay.
Any other questions for me? I see my time is up.
Thank you. Thank you very much for your time. Mr. Gill, we'll get you up at the podium for just a few minutes, please.
Thank you, Judge. And I'm winding it down here, but one of Mr. Herbst's arguments implicates something that you had said to me earlier, Judge. In your example about painting, and I sell the painting to somebody, and we have another jilted buyer who wanted it but didn't enter into a contract for it, and they want to sue for it. Just because we're bringing different claims under the same core set of facts doesn't mean they're all the same claim, and it doesn't mean they're all the same, governed by the same statute of limitations. And that's what we have here with regard to enforcement of the mortgage. There is no question that Wells Fargo and Federal Housing Finance Agency has considerable latitude in enforcing without taking into account competing considerations or competing liens. They have considerable latitude about enforcing the mortgages they acquired under this legislation. And Congress intended for them to have the ability to have a 3-year or a 6-year statute with regard to their enforcement of whatever they're doing with regard to a mortgage. But usually what we're talking about is enforcement of the mortgage itself. And in this case, that's the claim against Mr. Sutcliffe. That's not a one-size-fits-all for any other claim that could be made against any other party. For example, if somebody damaged the property somehow, they damaged a structure on the property, or they left unlawful pollutants on the property, that would be a different claim. It wouldn't necessarily be governed by the same statute of limitations. And that's what we have here. We can't fit everything into the same hole, which is what counsel for Wells Fargo is trying to do. And in recognition of Your Honor's comment earlier about the Ninth Circuit decision, which I looked at, and I mean no disrespect to counsel, who I know is counsel of record in that opinion, but the opinion was threadbare in the Ninth Circuit, the M&T Bank decision, with regard to any analysis about really why one statute should apply over another. And the same thing is true with regard to Judge Ross below, and I mean that with due respect to him. I think he did his best trying to grapple with these issues. But one thing he did not do was conduct any analysis on the difference between the 3-year statute and the 6-year statute under HERA. He just assumed it was 6 years and went with that. Well, that's an error too, for the reasons Your Honor was mentioning with regard to leave to amend, where the law says you're required to consider different factors. Your failure to consider appropriately different factors means you've abused that discretion. And I think the same thing is true with regard to statute of limitations by Judge Ross below. He only looked at the 6-year statute. There was no discussion about whether the 3-year period may be applicable or why. And I think that was wrong.
Can I ask you focusing on the comment you made about the idea that arising out of a particular transaction, for example,
Sure.
You might be suing, and you might be suing multiple people, and you might have different claims against them, and they might be subject to different statute of limitations. So I get that abstract thought, but I'm wondering, I guess, if the nature of my claim is, let's say again, in that painting hypothetical that I was using, if I'm the person who claims a contractual right to purchase the painting, and I sue both the person who's in contractual privity with me, the person who promised to sell me the painting, and then someone who now is in possession of it. And my claim is I have a contractual right to that property. That's that's how I frame my claim.
Mhm.
And the third party who is now in possession of it says, well, that's really interesting, and you could go fight that out with the person you're in contractual privity with, but I have I'm a bona fide purchaser, and so your contractual claim is of no concern to me and no basis for relief against me. Does that transform my claim against that person so it's more in the character of a tort? Or is it really more contractual in character? Because again, it's kind of predicated on, as I'm framing my claim, here's a contract, I have a right to this painting.
Right.
So that's what puzzles me a little bit.
Well, it's hard for me to answer that because it's, the question is kind of broad. So what do I envision as a litigator? Well, I see a contract claim with regard to the party that you're in privity with, and I see a tortious interference claim perhaps by the other party. That's what is most apparent to me. But here, what we don't have is, against Ms. STAAB, we don't have a claim to enforce a mortgage against her. She's not the mortgagor. She's not in privity with the bank. It's a different claim. and it's governed by a different statute. That's what we have. Square peg, round hole.
Thank you,
very
Mr.
much.
Gill. Thank you, Mr. Herbst. We appreciate your arguments today. The case will be submitted. The third case on our calendar today is 24 CO 162, United States versus DAMAIRZIO M. Wells.
Good morning, and may it please the court, Dan Lenners for the United States. If I might reserve 3 minutes for rebuttal. The Supreme Court has made clear that before applying the exclusionary rule, courts must engage in a rigorous balancing of the deterrence benefits of the rule against its costs. Those costs are always substantial, but are particularly substantial here, where exclusion would affect not only this case, but the many cases in which the government's evidence relies upon GPS evidence obtained through monitoring before this court's decision in Davis. And the benefits of suppression on deterring CSOSA as an agency from enacting unconstitutional regulations and policies are minimal to non-existent for 2 independent reasons. First, CSOSA as an agency is already deterred in myriad ways from acting unconstitutionally through things such as notice and comment rulemaking, congressional oversight, and this court's ability to declare its regulations and policies unconstitutional as occurred in Davis.
But doesn't this case demonstrate that these alternatives didn't work so well?
The fact that it
Right.
didn't work doesn't mean that it's necessary to deter CSOSA. I mean, that was true for legislatures passing unconstitutional statutes, and the Supreme Court nevertheless found in Kroll that declaring them unconstitutional was a sufficient deterrent, and that
Right, we
exclusion.
weren't talking about, I mean, in Kroll, we were really talking about the police officer, right? I mean, here we're talking about CSOSA acting and CSOSA creating its own policy, right? It's unified, right? They get to decide for themselves what they are doing, or so they thought, right? Seemingly in complete disregard for the statute that set forward their authority and made it very clear, CSOSA, you're like probation officers. Very, very, very clear in the federal scheme. Probationers don't put GPS monitors on their supervisees, right? And just, I mean, no cases, right, where that was happening. So super clear that that's really not part of their authority. And yet they create a policy statement and promulgate some regulations. And to your point about, well, they're deterred because of notice and comment, they just did it and nothing happened. And then when finally someone said, wait a second, this is a problem, this court said, no, you can't do that. That's completely outside of the statutory scheme that Congress set up in the Revitalization Act.
So I disagree that it was that clear. If it had been that clear.
Well, that's what that's what we said in Davis. So, I mean, you can disagree that that's the history, but that's kind of the history that we laid out in Davis.
I disagree that it's that clear. This court in Davis said that's the correct interpretation of the statute over a dissent. And CSOSA had been engaged in GPS monitoring publicly pursuant to public regulations, pursuant to public policies for nearly 2 decades. And it took that long for anyone to suggest that what CSOSA was doing was unconstitutional. I think it's ahistorical to say that it was so abundantly clear that what CSOSA was doing was unconstitutional.
Well, I mean, let's talk about how public it was, right? I mean, they started this policy in 2003, but they don't put out their policy statement until 2009, and they don't put out their supervised release. Well, actually, their regulations are from 2001, so even predate GPS monitoring. So it's not really that they're putting out the regulations to bless GPS monitoring. When they put their regulations out in 2001, GPS monitoring doesn't even exist. So the policy statement goes out in 2009, and I don't know who's seeing that. I mean, yeah, they're talking to Congress about budgetary matters, but no one's talking about the authority to impose unilaterally GPS monitoring separate and apart from the Parole Commission. That's never comes up, and it's just not a topic of concern. And then, finally someone says, wait a second, we don't really think GPS, the CSOSA should be doing this. And in Jackson, we say, okay, well, GPS monitoring doesn't have to be ordered by a court. You can do it under this special needs analysis, but Davis is being litigated even as Jackson is being decided. And then we decide Davis and say, you don't have statutory authority to do this. I mean,
I understand the court's ruling in Davis, and we are not fighting the correctness of that ruling. But it wasn't clear or obvious. There was no flagrant misconduct by CSOSA, particularly given, for example, Jackson, looking at this precise statutory scheme, looking at 24-133, identifying that as the source of CSOSA's authority to engage in GPS monitoring, and then saying it's a constitutional Fourth Amendment warrantless search. It's hard to, I think it's completely
the issue wasn't presented in Jackson. In Jackson, the issue was, do you need a judge to issue a warrant? Right? That's what the issue was in Jackson. And then, I mean, these things take a while to evolve, but the government wanted their GPS monitoring system, or CSOSA's GPS monitoring system, to be blessed by the courts. And so, asked for it to be blessed under the special needs analysis, and to reject the argument that there needed to be a warrant issued by a judge. And this court said, okay, we agree, you don't need a warrant. And then, then a new argument was made, well, wait a second, under special needs, you need to have actual authority to do the thing that you're doing, and you don't have that. And we immediately said, you're right.
I just think that does not accurately characterize the obviousness of CSOSA's error whenever it occurred. In 2001, when CSOSA promulgated the regulation that this court declared unconstitutional in Davis, no one had said that GPS monitoring is a search. The same was true in 2003.
GPS monitoring didn't exist.
The same
It
was
didn't
true
start until 2003.
And CSOSA finalized its regulations in 2003, and there was again no complaint. The Parole Commission routinely, in its regulations and its parole manual, said that probationers must comply with the sanction schedule adopted by CSOSA, a sanction schedule that included electronic monitoring. In 2009, when CSOSA enacted its policy, you were still 6 years away from the Supreme Court holding.
You said enacted its policy?
Adopted its policy, promulgated its
Okay.
policy. I misspoke, I'm sorry.
Council, can I, maybe a welcome pivot? Can I get you off the regulations for a second? I mean, I tend to agree. I did not think the ruling in Davis was so obvious. I don't think, as a member of that panel, that I would say today that it was obviously correct. I obviously happen to think it was, but I think that was a close call. But I just want to kind of pull out a little bit and kind of ask about what framework we should be looking at these questions under. Your brief says a lot with considerable support in the other Davis, Willie Jean Davis, that in order for the exclusionary rule to quote unquote pay its way, police misconduct or sort of the Fourth Amendment violation needs to be deliberate, reckless, or grossly negligent. If that's right, I mean, I guess I'm going to have a two-part question. One, do you think there's a limiting principle? If that's what you think the rule is, do you think there's any limiting principle to it? And then two, if not, have we been doing everything wrong for the last 13 years? I mean, we just decided an en banc case in Mayo, where I would not say that officer acted unreasonably. I mean, we found it was an unreasonable search and violative of the Fourth Amendment, but I think one could reasonably disagree with that. Same with just tons of cases where we have suppressed evidence in the last, since Davis. And in those cases, the government tends not to argue good faith. And And I'm just wondering, sort of, I mean, take those two questions as they come. One is there a limiting principle? And if not, do you think we've just been messing this up over and over and the government's been mistakenly failing to argue good faith in sort of the most routine of Fourth Amendment cases?
I think it's unclear post Davis where the Supreme Court is heading. It has not yet applied the deliberate, reckless, or grossly negligent test to an officer performing a search on the street in apparent good faith belief that the search was lawful. And then the court subsequently finds it's a close question, but it's unlawful. So I think the answer is it's unclear whether Davis is indicating a coming revolution in exclusionary rule jurisprudence, or if the Supreme Court would limit it. And if the Supreme Court would limit it.
Rather than trying to read tea leaves and predict things, you could be saying one of two very different things. One is, it's not clear if that revolution has come just yet. If Davis was the revolution, or if it's merely presaging a revolution. Or you might be saying the revolution hasn't come yet, but there are signs that it's coming. Which one of those two things are you saying?
I don't think to rule in our favor, the court has to completely revamp exclusionary rule jurisprudence and find that Davis revolutionized things and requires a finding of flagrant misconduct for an officer on the street committing a Fourth Amendment violation. To rule in our favor, the court doesn't have to find that Davis means that much.
And that may be true, but I'm still interested in your answer to the question, essentially, of what do you think our marching orders are? How what are we bound by in what the Supreme Court has done? And so let me put it this way. Imagine that a case comes up tomorrow, which is an officer on the street who makes a reasonable articulable suspicion call that the division of the court thinks, wow, close call, no clear precedent, reasonable officer could have thought either way, but on balance, we think unlawful Fourth Amendment violation. And imagine that the United States argues to us in that case, the Supreme Court has announced, binding principles about how to decide exclusionary rule cases. It has said suppression is a last resort. That's your framework. That is a mandatory framework. That's not a limited framework. That is just an absolute. That's the rule of law that you are to be applying. And imagine the United States also says, and the Supreme Court has also said that in order for suppression to be warranted, it has to be the officer's conduct has to be culpable in the sense of being intentionally unlawful, reckless, grossly negligent, or maybe systemic, the product of systemic negligence. So imagine that argument is made to us. And imagine that the defense responds by saying, I mean, there's language like that in Supreme Court cases, but it's not clear it's extended that far. And there's language in this court's cases which say, including in the reinstated part of Mayo, that says there is a general rule of suppression. So we're going to suppress unless there are kind of unusual circumstances that point the other way. That's really what you should be doing. Which principle of law should we be applying? What is our framework?
I think the limiting principle that Judge Steele asked for that applies is the difference between the officer using his hurried judgment on the street versus more.
But just to be clear, I mean, when you say that, it sounds like you are acknowledging that it would be too broad of a reading of the Supreme Court cases to say there's a flat rule. It's the ratio decidente of these cases. A lower court cannot deviate from it. No suppression unless last resort and culpable police misconduct. You're saying that you don't think that has been established in a way that is binding on us across all cases yet. That's, there's broad language to that effect, but a division of this court, you're saying, would be free to say, well, that's interesting. The Supreme Court has said it in certain settings. We've been doing something different, at least in settings where we're talking about officers on the street making quick calls. And so we're not going to be applying those principles in this setting. Am I right to understand that you're not arguing that we're sort of already bound to just, no matter what, be applying that in all settings?
I think of it differently, Your Honor. I think of it as the Supreme Court or this court would likely characterize that officer's conduct as at least grossly negligent insofar as the officer conducted what the court finds to be an unreasonable search or seizure. And therefore, looking at the situation objectively, that by violating the Fourth Amendment.
That answer seems very puzzling to me. I don't think it would be very likely, at least I wouldn't be very tempted to say of an officer who, let's say there's a question of whether circumstances A plus B plus C equal reasonable articulable suspicion. And, this court hasn't decided, courts around the country are closely divided on it. And a number have said yes, some have said no. And, we look at it and we end up thinking better conclusion, reasonable people could disagree, better conclusion is not enough. I would not be very tempted to say, well, that officer's conduct was grossly negligent. Why would I say that? I wouldn't think it wouldn't seem like a plausible conclusion to reach.
All I can say, Your Honor, is that the Supreme Court has not yet applied the Davis formula to individual officer decision-making on the street.
Right, and my abstract question is, and I think I'm getting an answer, at least implicitly, so correct me if I'm drawing an incorrect implication from the way you're answering the questions. One simple answer could be, well, they haven't also said it happens on Tuesday or Wednesday or whatever else, but they have announced a rule of law that is binding on courts in all settings. You're not arguing that. You haven't said that today, and I'm inferring that that means that's not the position you're pressing for in this case. Am I misconstruing what you are in our argument?
That is not the position we're pressing for in this case, because we don't think the court needs to adopt it here. In this case, there are multiple reasons.
Well, so let me, if instead the framework in some settings, and maybe this one, is instead there's a general rule of suppression. You should suppress unless there are like unusual reasons not to, good reasons not to. Sort of suppression is non-suppression is the exception and suppression is the norm. Then I think this case gets to be pretty difficult for the United States. And I can wrap back around to Kroll, but to the extent there's an analogy to Kroll, it seems like a difficult one here. I mean, Kroll was a very closely decided case. It was 5-4, and so one could wonder how broadly it should be expanded. And it seems quite different. I mean, the question of whether reasonable officers, or whether you would deter officers from relying on, what is done by a different branch of government that the court in Kroll thought there really were systemic reasons to need to deter. That seems like a whole different picture than whether there are reasons to deter or concerns about the need for deterrence of whether you're focused on an individual CSO, probably that individual officer is going to do what the agency says. So it's really more about deterring the agency, it seems like here, on the broader question of overall authority. But if it's an agency that it's not, we know from the special needs holding of Jackson, it's not engaged for these purposes in the competitive exercise of ferreting out crime. But it seems it's clearly a law enforcement agency. It's clearly allied with law enforcement, and it clearly is coordinating the results of its searches and the conduct of its searches with law enforcement agencies. It seems like a world away from concerns you might have about deterring legislatures. So, I mean, Kroll seems like a very distant analogy.
I guess I have two things to say there, Your Honor. The first is the Supreme Court has repeatedly said, and with more urgency recently, that suppression is a last resort, not a first impulse. That seems.
I understand that.
That seems to.
I understand that, but I take you as saying that's not really, because again, we say in our cases, including recently, we more typically say it is the presumed result. The general rule is suppression. Now, are you saying to the extent we have said that, we need to disavow it because the Supreme Court has a binding different framework? Again, I haven't heard you say that yet. So that's what, that applies in this and all settings. I haven't heard you say that. So that's why I'm a little puzzled about how much to make of your reference to the fact that in settings that your opponent tries to distinguish factually, the Supreme Court has said that suppression is a last resort. Which is it? Is suppression, if we're writing our opinion, should we write suppression is a last resort and here's why it's not appropriate here? Or should we write suppression is the general rule and here's whatever we think about that?
Well, you should definitely write it's not appropriate here, regardless.
Got that.
I guess my attempt to reconcile the two is to say that when you're talking about Fourth Amendment violations by police officers on the street, that it's fair to say that both this court and the Supreme Court has treated suppression as the rule with few exceptions. But in other circumstances, such as exist here. The court has emphasized that suppression should be the last resort, not the first impulse.
Is part of, I think earlier you partially answered that sort of the dividing line between these cases. It's not a perfect dividing line, but a rough one is, most of the good faith cases involve officers relying not on their own judgment, but on some, call it a superior authority, whether that be the legislature in Kroll, whether that be binding precedent in Willie Jean Davis. And I take it, you want to say, well, this is like that. This is this is a CSOSA officer who has some superior authority. I should have said also a judge in Leon, that's the typical good faith example. A judge has signed off on the thing. And this case is like that this is a CSOSA officer who's relying on a superior authority with no real reason to doubt that authority. That's the better decision maker. We'd prefer these things be decided systemically. And if that's part of your analysis, then we kind of have to move over to the policymaker and say, well, what kind of incentives are acting on them? And in Kroll, we said, well, there's no real incentive to skirt the law by the legislature. In Leon, you can say, well, there's no real incentive for judges to skirt the law. And Willie Jean Davis, well, that was another court that decided this was the rule, so they wouldn't have skirted the law. And so the question just kind of shifts over to, well, what do we think about CSOSA in terms of the incentives of it? Is that the right way of thinking about it? I mean, that's kind of how I kind of see this case in a box of other cases where an officer is relying on third-party decision makers, with the analysis then shifting over to, well, what do we think about that third-party decision maker and sort of the incentive and disincentive effect of suppression on them?
Yes, that's exactly how I think about it, Your Honor. And I don't understand the defense to be arguing that deterrence is necessary here vis-a-vis the specific court supervision officer, who at the time she ordered GPS monitoring in June 2023, had a regulation saying that electronic monitoring was appropriate, formal policies that had been in place for 14 years, saying under these circumstances, GPS monitoring should be used, and 2 decisions by this court saying that GPS monitoring did not violate the Fourth Amendment.
For sure. I don't think they're making that argument. If they're making that argument, I don't think it flies. So
then
we're kind of got to move over to CSOSA.
And that's where I think tried to begin my argument, which is talking about all of the reasons why CSOSA as an agency, any incremental deterrence benefit of suppression would be outweighed by the costs. And that's what we're talking about here. We're talking about that incremental deterrence benefit in addition to all the other deterrents. And those deterrents at an agency-wide policymaking level are notice and comment rulemaking, congressional oversight, presidential oversight.
I guess, I mean, let's just be really practical here. If CSOSA put GPS monitoring on its supervisees illegally, and then the results of that monitoring were suppressed, you don't think that that would have a deterrent effect on CSOSA having illegal policies?
Not more so than this court in Davis declaring their policy unconstitutional. I mean, that's what the Supreme Court said in Kroll. Legislators are going to be motivated by having.
But if we say it's unconstitutional and then say it has no impact, like doesn't, right? It's like Hudson knock and announce, right? You're not supposed to do it, but it doesn't impact the search, right?
It doesn't.
I'm not following the deterrent effect.
It doesn't retroactively benefit the defendant, but that's not the purpose of the exclusionary rule. It's solely focused on forward-looking deterrence of CSOSA as an agency. That deterrence is accomplished by declaring that policy unconstitutional. Going forward, they are going to be more careful about their regulations and policies, knowing that this court will strike them down.
But why? They've gotten the benefit of the policy that they've had in place for a couple of decades. What sting is there to CSOSA of something saying, we strike down that policy, don't do it anymore, but there's not going to be sort of any trickle-down effects? What sting results from that would prevent them from tomorrow, I don't have an example at the top of my head, but pushing the envelope, right? We suggested a couple other policies. I think revoking offenders and sending them to halfway houses might not actually be part of CSOSA's graduated sanctions program, might not be authorized as graduated sanctions. I don't know if they've changed that policy since we suggested that. I don't think I've heard of it. So what real, motivation do they have if at the end of the day, they've gotten kind of 20 years of benefit on this monitoring without, what's the cost that I'm missing? I don't really see it.
So the cost is going forward, they have to be more careful, knowing that this court will strike it down, knowing that the director then has to go testify before Congress and talk to the oversight bodies about why CSOSA has been enacting multiple unconstitutional policies. The fact that they have to publish future regulations pursuant to notice and comment, and if they get comments that they're unconstitutional, have to explain that decision. I mean, they can be sued under their officers can be sued under Section 1983 for money damages, which the Supreme Court found in Hudson was a significant deterrent. All of these together amass to significant deterrence from this sort of behavior by CSOSA in the future, such that suppressing evidence in a single case is incremental to the point of being ineffective.
Well, you say a single case, but that seems a little granular about how to figure out what the pros and cons would be. I thought you started by saying suppression would be very costly because it would be cut across a whole swath of cases. So I think the deterrence and the costs are going to have to be, whatever the right degree of generality is, are going to have to be the same. So or should we be thinking of the costs as sweeping and deterrence equally so, or should we be just looking at a single case in isolation?
I think that the costs are higher than in the normal case, given that there are going to be multiple cases affected. And the Supreme Court has repeatedly emphasized the substantial societal costs of letting a guilty and possible dangerous defendant go free in just a single case. In terms of deterrence, even if it affects half a dozen or a dozen cases, I don't think that amounts to more than.
What's your prediction? Are there going to be a lot of cases where suppression is an issue or not many? It's relevant to both sides of the equation potentially, but it seems like depending on what time when you're talking, I'm getting different pictures about the magnitude of what's at stake here. So
there's no publicly available information. We have cited to probably 5 cases from this court that involve GPS monitoring in the last 5 years. I think that probably understates how often GPS monitoring is involved in obtaining evidence in a case. This case is not atypical in that there's real-time GPS monitoring that leads to an arrest and seizure of evidence. That the same thing occurred in Jackson. We cited one pending case where the exclusionary rule issue came up, and so I think it would be a dramatic exaggeration to suggest 100 cases, but certainly more than a handful. And I can't be more precise than that in terms of a guesstimate as to how many cases it would affect.
Just to wrap back, I apologize for wrapping around to part of what was at the front end, but I take it that, well, let me put it this way. If we were to write an opinion that started by saying, here's our framework in this context, suppression is the general rule, and we're looking for special reasons not to suppress. You think that would be legally incorrect?
Yes. I mean, it's squarely opposite to what the Supreme Court has said.
Right, but I thought you said that we could say it's true that the Supreme Court has said that you have to have at least a culpable mental state of up to gross negligence or maybe systemic negligence, but the Supreme Court hasn't made clear how far that goes, and it's not clear it applies here. So I just am. It is contrary to what the Supreme Court has said. The issue is whether the Supreme Court's statements are binding as flat rules without regard to context, or whether you think no, as I think you're acknowledging, they're not yet sort of binding across all contexts, including an officer's individual judgment on the street. And then it's left to us to decide, I guess, what's the line between where it isn't necessarily binding yet, even though they've said it generally, but they haven't applied it, that broadly. And where somehow it starts becoming binding, short of where they've already applied it, because this is different from any case where the Supreme Court has applied it. It's not like Kroll. I mean, there are analogies to Kroll, but also disanalogies. So we're kind of in the middle where the Supreme Court hasn't already applied that general language to circumstances exactly like ours.
So if you started the opinion with exclusion is the rule, then I think you are implicating those Supreme Court cases. And so it would have to be more nuanced than that and trying to, find this line of where the Supreme Court, intends courts to take that approach. And when that approach, I think the Supreme Court has not yet applied it. And there it's officers' individual judgments on the street who are most prone to deterrence, the Supreme Court has repeatedly said, where we are most concerned with officers conducting many searches that don't lead to any evidence and then find evidence in a search, and thus we need to deter them. I mean, these are the things the Supreme Court has said in its cases for the need for deterrence in that scenario that don't apply here.
So just to follow up on Judge McLeese's question, and understanding that, you see a lot that we need to grapple with in the Supreme Court case law, but do you think that we as a panel could come out and say, exclusion is not the rule, given prior statements by our court where we've said that it is?
I don't know the answer to that, Your Honor.
Just to add to the fun of that, we also have said suppression is a last resort in at least one of our cases. So, you can pick from column A or column B as you like on that topic.
There's my answer, Your Honor.
No, it's not, that's not an answer. It's just another complication that makes answering it difficult, I think.
If there are no further questions.
Thank you. We'll let you sit down.
Good morning, Your Honors. Paul Maneri on behalf of Appellee DAMAIRZIO Wells. I'd actually like to address both arguments that we raised in our brief, but I will start with the broader argument that we've been discussing. We know this exclusion will have a significant deterrent effect on CSOSA for three main reasons. First, given CSOSA's own interests as well as those of its law enforcement partners, the agency has a strong interest in the use of its GPS evidence in criminal proceedings, and based on that interest, CSOSA is responsive to the deterrent effect of excluding unlawfully obtained GPS evidence. Second, no binding authority from any judge, court, or legislature authorized CSOSA's GPS searches. The search in this case was instead the product of CSOSA's own erroneous effort to expand its authority beyond what its statute allowed. Applying the exclusionary rule in that circumstance will deter CSOSA from overreaching in future decisions where constitutional rights are at stake. And third, exclusion will have an especially strong deterrent effect here because unlike the rush judgment of an officer on the street, exclusion here will directly influence CSOSA's policymaking decisions, which are inherently deliberate and sensitive to deterrent forces.
All right, so you've kind of skipped over the predicate question though, which I think we were trying to get the government to try and nail the government down on, so let's try to nail you down on it. At least Willie Jean Davis says exclusion is unusual, and it seems to say something like it's reserved for deliberate, reckless, or grossly negligent disregard of Fourth Amendment rights. So let's say I think CSOSA's policy was unlawful. I think it wasn't deliberately so, it wasn't recklessly so, or grossly negligent. It was sort of a reasonable interpretation of a convoluted statutory scheme. That doesn't seem to meet the Willie Davis standard of growth. I mean, I know you have an argument that it does. I know you have an argument saying that it was unreasonable, but let's say I don't think it is. So is it deliberate, reckless, or grossly negligent? Is that the right way of should I be applying? Is that the new rule? Is Willie Jean Davis what applies now?
No, and I have three, maybe 4 points that I'd like to respond to that question with. First of all, as I think Judge McLeese was alluding to, that language from Willie Jean Davis is dicta. It does not control the outcome of this case. You can look to Justice Sotomayor's concurrence in Davis, which says that whatever we've said about culpability, the ultimate questions about whether to apply the exclusionary rule have always been, will it significantly deter constitutional violations, and are the benefits of that deterrence greater than the costs.
I mean,
Right,
that was, her vote wasn't necessary to the majority in that case, was it? Wasn't it? That was a 7-2, I think.
That's right. But you can also look at the majority opinion. I mean, the language that talks about deliberate, reckless, grossly negligent, that comes from section 2 of the opinion. The court's analysis is in section 3. So let me move on to my second point.
Before you move on to it, just by parity of reasoning, do you think our decisions that say suppression is the general rule is dicta? That language too is dicta. It's like, yeah, it's general language and you got to just look and see what happened in a particular case. Or do you think somehow it's less dicta-ish when we say it, and if so, why?
My instinct is that it's dicta, if it's not, actually determining the outcome of the case. I think it's more of a background principle. I will pause on a sort of tangent to the 4 points that I wanted to respond to Judge Deal's question with, and say that I think it's completely consistent to say that suppression is a last resort. And it's also the general rule. Once you get through all of the doctrines that you have to get through to get to suppression, right? It's the last resort because we have to determine that there's not an attenuated interest, that there's not an attenuation from the illegality and the evidence that's being challenged. There's not an independent source doctrine. There's not inevitable discovery. There are all these things that you have to get through, right? And we have to determine, is it a criminal proceeding or is it a different proceeding where the interests of the seizing officers aren't really affected? So in that sense, I mean, those are the settings in which the Supreme Court is saying suppression is a last resort. We don't just suppress evidence from any old proceeding because there's been a constitutional violation. Once you get through all that, and it's a law enforcement officer, doing an illegal search, and the government seeks to use that at a criminal trial, when you've gone through all the other doctrines that you go through, and you're now at suppression as a last resort, as a general rule, you suppress. There is no additional inquiry beyond that. Davis does not add an additional requirement for culpability. And so pivoting back now to Judge Deal's question, the language that the government is emphasizing from Davis is dicta for the reasons I've described. Obviously, it's still Supreme Court language. So what does that dicta mean? I think if you look at it in context, the central connection that the Supreme Court has drawn from Leon all the way through Davis between culpability and deterrence, and remember, deterrence is the ultimate question here, is if the police were not actually the ones who are to blame for the search being illegal, in the sense that, if in Leon, a judge is saying you can do this search, or if in Davis, an appellate court is saying you can do this search, or Kroll, a legislature.
Right, so just to interrupt, you heard my colloquy with opposing counsel where I tried to sort of frame where he thinks the fight is in this case. And I hear you kind of parroting the same understanding. So let me just, is that right, to that sort of Davis, Leon, Kroll, that line of cases, Herring maybe is a little bit different. No, it's still kind of on point, is where an officer is sort of resting their judgment on a detached third party decision maker. They're kind of faultless, so we're not going to automatically suppress. And then we kind of move our focus over to the third party decision maker, and we ask ourselves, well, what are the incentives and disincentives like on that third party decision maker when determining whether or not suppression is necessary? The Supreme Court has said, well, judges, you don't need to disincentivize them. Legislators, you don't need to disincentivize them. Binding precedent like Davis, that's not going to be any disincentive to the courts. Maybe, a clerk who's typing in warrants or like responding to officer phone calls, they're not going to be disincentivized by suppression. And this is where you started. So I take it you agree. You think the fight in this case is over whether Sosa is more like the judge, the legislature, the clerk who's taking warrant calls, or is it more like, a superior officer who's directing or an internal MPD policy that directs when to do searches? Is that sort of when we're trying to figure out which box to put Sosa in terms of how the incentives and disincentives of suppression operate on them?
Yes, I think that's the right framework. I mean, the court has said in all of its good faith cases, and remember, good faith is a misnomer. It's really talking about objectively reasonable reliance on some other authority or information, right? And so if the police are acting in objectively reasonable reliance on some other source, then it can't really be said that they are culpable in the sense of assigning blame right? So penalizing the officer for the magistrate's error cannot logically contribute to the deterrence of Fourth Amendment violations. That's the language.
But just to pause there, why isn't every ordinary Fourth Amendment police officer on the street fill into that bucket too, where, you know, presumably they've been trained? You know, you could have officers say, well, yeah, I read Illinois v. Wardlow, and somebody gave me the bullet points and they told me, if you're in a high crime area and somebody runs, you can stop them. That seems like a fairly reasonable reading of Illinois v. Wardlow. So why wasn't that? Why can't I put that into the box of the good faith exception, where you're relying on some third party, a court, and giving a reasonable interpretation of its cases?
Because, Your Honor, in the hypothetical you just described, the officer is still relying on legal judgment or the legal judgment of whoever trained that officer to extrapolate beyond the general principles of the precedent on which they're relying. And this court said in DeBrule, you can't do that. If you're going to objectively reasonably rely on binding appellate precedent to block application of the exclusionary rule, it has to be binding in the sense that MAP v. Ryan talks about, where it decides all the material facts. And so we don't care if an officer reads the cases and is really diligent and comes to his own legal conclusion about whether circumstance A plus B plus C equals reasonable suspicion.
What about Hine? What about Hine, where it was, is that the misinterpretation of a state statute, a reasonable one? I know that wasn't a good faith case. I believe they said it was a reasonable interpretation, so the stop itself, and I think it was the stop that was an issue there. I can't remember. There's a lot of cases in this case going on in this appeal. So Hine was kind of an officer relying on his own interpretation, and the court said, yeah, not only no suppression, no violation at all, because it was reasonable enough to read the statute that way.
Right, but Hine is really a case about the reasonable suspicion standard and what suffices to meet that standard. And the legal mistake that was made in Hine related to the scope of the penal statute. So the court said, if an officer has reasonable suspicion that someone has committed a crime, it doesn't matter whether the mistake that they made is whether 2 headlights are out instead of 1, or whether the statute says, or whether the statute criminalizes 1 or 2 headlights being out. Reasonable suspicion is an imprecise standard. It doesn't take a lot to meet it. What was not at issue at Hine was officers misinterpreting or misunderstanding the scope of their search or seizure authority as a threshold matter separate from the scope of penal laws. Everyone agreed that that was not affected by Hine's holding. And as you said, Hine is not a good faith case. There's a different test that applies. Once there's been an antecedent constitutional violation determined, then we shift over to a different calculus. We're talking about deterrence. And as this court has said, application of the exclusionary rule where the law is unclear or unsettled will deter constitutional violations, because at that point you have officers exercising their own discretion and judgment. And it's at that decision-making moment that the exclusionary rule can influence behavior and provide an incentive to err on the side of constitutional.
I mean, I take the point made in your brief that this case is a fair bit different from Kroll. But it does seem, I mean, the deterrence inquiry is in part about how amenable to deterrence the decision maker is, and in part about how much in need of deterrence the decision maker is. So that both those things are kicking around. And if you focus on how much in need of deterrence CSOSA as an agency is, it seems like it's a fair bit different from police on the street in the sense that, I mean, we know police, I mean, there are thousands of cases where police have engaged in searches that were determined to be unlawful. So we know there's a huge empirical supply of cases that show there is a big need for deterrence, and that whatever other deterrence systems are out there, they're not adequate by themselves. And even the suppression remedy isn't adequate to completely prevent them. They continue to flow. CSOSA itself, or agencies like CSOSA, what's the, I mean, is there anything comparable? Is there, I mean, obviously one could look at this as a long, violation that had many instances. So you could say that's a lot, but it's like a single decision. And is there like a pattern of CSOSA really, it's out there, it's a rogue agency, it needs to be deterred. or that agencies that are like CSOSA and allergies need to be deterred in a way that is at all comparable to like the huge amount of data we have about the need for deterrence of officers on the street?
Yeah, I think the right way of thinking about this is thinking of CSOSA, first of all, as a law enforcement agency, second of all, as a parole agency. And there are two cases that I know of where courts have directly addressed whether evidence must be suppressed at a criminal proceeding where it has been illegally seized by parole officers. One is United States versus Payne, the 1999 Sixth Circuit decision that we cite in our brief, which held that yes, evidence must be suppressed in that scenario. Otherwise, it would be too great a temptation for parole officers.
Is that individual officers or an agency's
That's
overall policy? Because that's
individual
That seems
officers.
like a different, it's related. So I don't mean to
Right.
suggest what you're saying is not relevant. I'm just pointing out there does seem to be a distinction that's of potential relevance.
Individual officers. The second case, also about individual officers, which is not cited in our brief, so I want to make sure that I direct the court's attention to it, is People v. Willis, a 2002 decision from the California Supreme Court. It's 28 Cal 4th 22. And that case is important for two reasons. First of all, it addresses the government's argument that they make in this case that Scott, the Supreme Court case about parole revocation proceedings, the court in People v. Willis specifically rejected the argument that the government makes here and says that we read Scott to actually support the application of the exclusionary rule when it comes to criminal proceedings and illegal searches done by parole officers. The second thing that I think is important to note about People v. Willis is that they said we've surveyed the case law and we can find no authority to the contrary. That was in 2002, but I don't think the government has cited any contrary authority. I haven't found any either. To your point, Judge McLeese, those are cases about individual parole officers, but I think the logic applies all the more forcefully when you have an agency that has as its mission law enforcement and detecting new criminal violations. It applies all the more forcefully to that agency setting policy because when you think about what influence the exclusionary rule will have, we assume that it will deter constitutional violations when we apply it to the rush judgment of officers on the street.
Well,
We might not have.
I don't know if we assume it will. We hope that it will have some marginal effect in, because if we
Sure.
assume that it will, we're obviously, we have a very counterfactual assumption because it doesn't fully, for
Okay.
sure.
Whatever the rationale is for how it will deter the officer on the street, I think it applies all the more forcefully to an agency setting policy, presumably with general counsel, who can really sit and think about what are the consequences of this policy going to be. Are we going to be able to use this evidence in court?
But I get that line of thought, but your opponent's contrary line of thought is there are many other systemic countervailing deterrent effects, or I don't know if you call them deterrent effects, but preventative effects. So that the whole administrative agency and these are official actors, they have legal obligations to notice and comment, and that their argument is, I think, that there are other systemic considerations that make it less likely that suppression deterrence will be necessary. And I thought there's at least some limited authority for the idea at the regulation of agency level on maybe an analogy to Kroll for courts to be I found, I think maybe one appellate decision, but mostly, lower court opinions. There are at least some courts that seem sympathetic to the idea that agency action that was promulgated through regulation might well have some analogies to Kroll in a way that bears on the need for deterrence as a further remedy. And what's your take on that set of considerations?
The cases of which I'm aware that employ that reasoning are dealing with agencies like Department of Transportation or Department of Labor that I think are functioning a little bit more like a legislature where they're really not focused on criminal law enforcement. They're promulgating regulations. I think one of the
What was the Georgia one? The Georgia one was a little more law enforcement like. Was that like a customs enforcement type thing?
That is the
Oh.
only one that the government cited. I think it was a magistrate judge
That's right.
opinion from a federal court unpublished. And I don't think it grappled at all with the distinction between agencies and legislatures. And so I would say that, to the extent that there is an analogy to be made between legislatures and agencies, I think it would have to rest on the fact that agencies are not tasked with a primarily law enforcement mission. But when you have an agency that is a law enforcement agency like CSOSA, then the analogy sort of falls apart. I would also just say as a general matter for agencies, even those that are not specifically tasked with law enforcement missions, they enjoy an immense amount of power. It's not like a legislature where you have to compromise and think about, legislation for sort of the greater good. Agencies are created and given specific missions, and then they go out and promulgate regulations and policies in furtherance of those missions. So it makes sense when you have a law enforcement agency, that's going to be the primary consideration that they have when promulgating regulations and policies. And as we say in our brief, there is ample authority for the fact that agencies often figure out their policy first, figure out how to defend its legality later. That is sort of the incentive structure that agencies generally are working with. I think that tells you all you need to know about the APA and whether it is a sufficient deterrent in this case.
One interesting fact about this case is when the electronic monitoring went out on notice and comment, nobody said boo. I mean, there wasn't any, this might be unconstitutional comment from anybody. That might be enough to put an agency on notice that, oh, maybe we're in treacherous land, we should err on the side of caution. But what do you make of that?
First of all, I mean, it's the agency's responsibility to interpret its own statute. As I think Judge Easterly pointed out, when CSOSA promulgated its graduated sanctions regulation, I think that predated even the use of GPS. It certainly predated the understanding that GPS is a search. I mean, in 2015, when the Supreme Court decided Grady, alarm bells should have been going off at CSOSA. We've been conducting unauthorized searches, warrantless searches for hundreds of people a day. And the Supreme Court just said those are searches. What is our authority to do this? And then I think once you look at the statute, which Mr. Davis filed his motion to suppress in 2017, so there's not this huge gap of time where nobody had thought about this. Once Grady was decided, it took 2 years for a criminal defendant to say, hey, where was your authority to put that GPS monitor on me?
Wait, I thought Davis didn't actually make that argument initially. I thought part of the Davis opinion was, we're going to allow him to raise a late breaking lack of statutory authority argument because Jackson, I thought that was part of the argument.
I think it was a bit muddled as to what exactly the claim was below in Davis, but I believe there's a footnote in Judge Easterly's opinion that says that at least the trial judge was asking where was CSOSA's authority to even put the GPS monitor on in the first place. The point
I don't
is,
know why you're calling it Judge Easterly's opinion.
wait,
I think it was
the opinion for the
little hurt.
court written by Judge Easterly. Yes, so I mean, all of that's just to say, I think the notion that APA notice and comment procedures, which have been roundly sort of criticized as not really having any teeth in terms of constraining agency power, that can't be a sufficient deterrent here. And the other deterrents that the government looks to, I mean, are equally applicable to police. Police officers are also subject to civil liability. We don't say, well, that's good enough, no suppression. The government does not counter the case that we cite where the Supreme Court held that federal agencies like CSOSA enjoy absolute immunity for their policymaking decisions. So that kind of liability is certainly off the table. All you're left with is Bivens actions against individual CSOSA officers, and the Supreme Court has winnowed Bivens essentially to his facts. I would be pretty worried if we were relying on Bivens liability as a deterrent to constitutional violations in this case. And I think that's really all you're left with. Let me say a quick word about the second argument in our case. I know we haven't spent any time on it here. I do think, for all the reasons we've talked about, that CSOSA can and will be deterred by application of the exclusionary rule at an agency level. But even if you look at the individual officers' actions here, the government claims that they were relying in objectively reasonable reliance on the GPS policy statement, and the GPS policy statement does not cover the circumstance that led the CSO to impose GPS monitoring in this case.
The trial court didn't rule on that topic, didn't feel a need to in the way it was conceptualizing things. So we don't really have any ruling from that we'd have to be doing that work ourselves, including finding that there was a violation that related to that. Or is that, or do you think we don't have to separately determine whether that was unlawful?
You
We
do not
just
have to
say-
separately, that would be an alternate basis for affirmance and it would rest on a plain read of the.
Understood, but that would be a determination that there was a separate illegality, which is even leaving aside the illegality of CSOSA completely lacking authority to be imposing conditions of this kind. There was a separate constitutional violation, which was that taking, even if there hadn't been that one, it would have been unlawful and a not a lawful special needs search for the CSO here to impose this condition, given a proper reading of the interaction between the two policy statements that people were discussing. Am I missing that, or is that with that we have to first find that was itself separately unlawful if we were going to rely on that as a basis for suppression?
To my mind, there's one constitutional violation. It's when CSOSA agents put the GPS monitor on Mr. Wells. That constitutional violation, the reason that it was illegal, there are a couple of different reasons. One is the reason that the court explained in Davis. Another is that even if Davis were not on the books, the CSO in this case had no grounds to impose the GPS monitoring based.
I get that. It just seems to be logically what that's in substance saying that was not that's independently not a lawful special needs search. That is a logical prerequisite to having that be contributing to the suppression argument that you're making, like a case specific suppression argument rooted in that would rest logically on an antecedent determination that in fact that was not a lawful special needs search and that the CSO was wrong to think that it was. Is that correct?
That's correct.
And it's correct that the trial court did not rule on that.
That's also correct.
Is it also correct that, although I don't think the United States has made a default kind of argument about this, that issue was raised, like if I'm recalling correctly, like for the first time in a pretty tentative footnote about in a reply filing in the trial court? Is that?
I think that was raised at the hearing on the record.
Orally also?
Orally, yeah.
Because I mean, the footnote in the some sort of supplemental filing or reply was in the nature of, well, arguably or something. So it was pretty elliptical, at least in the written materials. And I recall there was some reference to it in the oral hearing.
Yeah. I apologize. I actually forgot a point that I wanted to make related to the first argument. So if I could step back, I know I'm over my time, but I did want to address the hypothetical that you asked Judge McLeese to the government about what do our cases say about, where an officer thinks that he has reasonable suspicion, it's a close call and reasonable minds can disagree, but this court hasn't weighed in yet. This court's cases tell you.
Oh, I wasn't asking what our cases say. I know what they say. So
okay.
I wasn't intending to ask that question because we have a clear answer to that under our case law. So I'm with you on that.
Fair enough.
Sorry, I don't mean to interrupt if you want to make your point. I was just trying to clarify. I was not asking that exact question because I think I know what the answer to it is.
I think you do, because the opinion I was going to quote was one that you wrote, Evans versus United States, 122 A3rd A76, which says that under this court's cases, close enough to the line of legality is not sufficient when the government was making a good faith argument premised on the notion that the officers were close enough. That doesn't cut it. Thank you.
Thank you, counsel.
Thank you, Your Honor. I'll try to make 3 quick points. Judge McLeese asked about the need for deterring CSOSA at an agency level. Other than the regulation struck down in Davis, in the 25 years that CSOSA has been an agency, there's no case by this court striking down its agency level action or finding unconstitutional any individual parole officer's actions. And so I think that speaks mightily to the lack of need to deter CSOSA from future Fourth Amendment violations.
So you think the agency has to have a track record for deterrence to pay its way?
I don't think it has to, but it certainly weighs in favor of finding no need. That's what the Supreme Court found in Kroll, that it found no history of legislatures or Congress enacting unconstitutional statutes, and that weighed against the need for deterrence. And I think it weighs against the need for deterring CSOSA as an agency, given its lack of history of problematic behavior. The defense characterized CSOSA as an agency with an interest in investigating new crimes. And that's just not what a CSOSA does. And I think we should take a step back and focus on what CSOSA's mission as an agency is. It's reformation and deterrence, meaning they want to prevent crimes. They want people under their supervision not to commit crimes.
Right,
And they
but
want to reform
if those crimes are committed, I think they also want to make sure that they're investigated and prosecuted by the government.
There needs to be some consequence when an offender commits a new crime, or else deterrence doesn't work. But fundamentally, CSOSA's
Right, but
focus is on.
if they're, employing means that are illegal and unconstitutional to discern that crimes have been committed and then turning them over to the government to be prosecuted, that seems to be problematic, no? I mean,
Of course,
doesn't
that's
that need to
problematic.
be deterred?
Of course, that's problematic, but the question is whether CSOSA will have an incentive to commit constitutional violations in order to uncover evidence that the people under its supervision are committing crimes. And there's no evidence that CSOSA is inclined to do that, nor is
I
there
just
any
don't
specific-
understand why this case or why the GPS testing monitoring episode isn't evidence of that, right? I mean, in the policy statement, it says, hey, we're putting on GPS monitoring as part of a graduated sanctions continuum and as a mechanism for collaborating with the Metropolitan Police Department and other allied law enforcement agencies to track criminal behavior of designated CSOSA offenders.
I just think it's an ahistorical misrepresentation of the decision-making process to suggest that that was.
I don't understand how it can be
Fourth Amendment
ahistorical
violation.
if I just read from the policy statement of 2009.
At the time, that was 6 years before the Supreme Court even declared GPS monitoring to be a search. And they were doing this hand in glove with the Parole Commission, who this court said in
Right,
Davis.
but defense counsel just said, look, if you have this policy statement where you're announcing, we're using this tool because we want to help the police ferret out crime and we want to give them evidence to prove that crimes have been committed. And then the Supreme Court announces use of GPS monitoring is a search, right? You don't think that they have to reconsider this policy statement or a regulation that was promulgated in 2001? I mean, that inaction, I think, is troubling.
It's perhaps negligent, Your Honor, but there's no flagrant misconduct when 3 years later, this court looks at the same statutory scheme and the same GPS monitoring and says that's constitutional. And then it does it again 2 years later. And
But
when
only
Congress-
constitutional vis-a-vis the argument being made, which is, wait, who decides whether or not to impose GPS monitoring? Does it have to be imposed by a judge? No, it does not. It can be pursuant to some sort of special needs framework.
Correct, but if it was so obvious that CSOSA lacked statutory authority to do this, the court wouldn't have pointed to its statutory authority
You think
to
the
do
court
so.
would have just sua sponte said, oh, but wait, we see another constitutional problem that we'd like everyone to address? I mean,
I
it's
would,
not generally how we operate.
I think this court, when it sees a problem, will identify it for the parties and ask for a briefing on it. And finally, my third point, Your Honor, is that, regardless of whether the Supreme Court statements about exclusion being the last resort versus the rule for which there must be an exception are binding, certainly the language in Davis about the flagrancy of police misconduct being highly relevant to the deterrence rationale, the need for deterrence is binding. I mean, the Supreme Court says police practices trigger the harsh sanction of exclusion only when they are deliberate enough to yield meaningful deterrence and culpable enough to be worth the price paid for the justice system. And it traces that back to Leon. It says the basic insight of the Leon line of cases is that the deterrence benefits of exclusion vary with the culpability of the law enforcement conduct at issue. So regardless, the lack of culpability here is an important consideration and one this court must consider under the Supreme Court's precedents. Thank you.
Thank you, counsel. Appreciate your time. Some people doubted that we would get out of court before 1 today, but here we are. This case will be submitted and we stand adjourned. Thank you.